Adjournment request from item number 1 to 5. From item number 6 to 16, adjournment request.
May please, Your Lordship. With regard to item number 14 and 15, my lords, this bench may not like to take up this matter with regards to the same Barketri College.
So it'll have to go apart from 11 to 15, no?
14 to
14 and
14 and 15, my lord.
But 12 also is analogous, no?
No,
12,
no,
12
no.
is not.
12 and 13.
Okay, 14 and 15.
That correct.
Yeah, with respect to 14 and 15, I say, no? Let these two appeals be listed before a bench, of which one of us, bracket, Justice Arundev Chaudhary J, is not a party. Place these two appeals before the Chief Justice on the administrative side for allocating a bench for these two cases. All right, yes.
Obliged.
Hey, please, Your Lordship. Lordship, I beg to mention item number 7.
You have circulated this slip. All right. All right. Yes. Give a date.
Yes, November. 6 November. Item number 17, 18, adjournment request. Any other request?
May I please, Your Lordship, my lord, I beg to mention for listing of a pending writ petition, my lord, the rule is under challenge regarding the appointment of Hindi teachers, my lord. My lord, selection is going on and the post is also going to be filled up. My lord.
September 25th.
Right.
September 25th.
Obliged, my lord.
May it please, Lordship. I beg to mention listing of a case, Lordship, in the hearing list, Lordship, letter is 103, Lordship, item number. What order is you can learned judge, learned Lordship has passed order, Lordship.
I can only see the gestures. I can't understand what you're talking.
Look.
What is the urgency? Which is the matter? Why do you want it to be listed?
Yes.
urgently?
Yes. The agency is, Lordship, agency is that the learned friend judge has allowed the petition, Lordship. So he may not.
So therefore it will be listed before another bench.
Yeah, yes.
Before the appropriate bench, sometimes you know. All right,
Obliged.
you take the date from the court master.
Obliged.
Daily list for item 1.
First time.
No, sorry.
Please, my lord. Lord, pursuant to the order dated 25/7, 25 July, my lord,
Yes.
we have filed the additional affidavit to include the selected candidate as respondent number 7.
All right. Okay, you filed the affidavit.
We have filed the additional affidavit, my lord.
Okay. A request has been made by the lead counsel for the applicant for impleading whom as the respondent number 7?
It is Kalita Amit. Kalita.
So as a respondent number 7 in the appeal, no? Respondent number 7 in the appeal. For the reasons stated in the application, the prayer is allowed. So and so is permitted to be added as a respondent number 7 in the main appeal. So a revised memo of parties shall be filed by the applicant appellant within a period of 2 days, whereafter the registry shall amend the memo of appeal accordingly, and the matter shall be listed before the appropriate bench. Then you have
Correct.
to, you're required to give some details with respect to the person. Nonetheless, we are permitting the impleadment.
Item number 2 for admission.
Yes,
My
you are
lord,
very diffident even to start the arguments.
my lord,
Mr. Bhuyan,
my lord. My
what
lord,
can be done?
admittedly, my lord, this selection is of long back, my lord, before my joining in the profession, my lord. My lord,
What can be done now? Tell us.
if my lord considers, my lord, that we were selected but not appointed, my lord, for certain reasons.
There is no record. And even otherwise, you are beyond the age of being trained.
That is correct, my lord.
That's very unfortunate, but then you also slept tight over the matter. We
No,
can't.
my lord, we continuously come before my lordship's, my lord, various orders were passed. Ultimately, my lord, an speaking order came to be passed, my lord, and in that speaking order also, my lord, it has been
Where is
reiterated.
the speaking order?
My lord may be pleased to find, my lord, is at page 420, my lord.
Yes, 24.
Copy দিচ্ছ? নাম স্ট্রোক, আপনার নাম স্ট্রোক করা। Copy দুটো না নিতে। এটা হয়ে গেলে PDF ফাইল তো সারা PDF
It's because of different understanding of the expression, the matter should be set at rest.
That is
Set
the,
at rest doesn't mean give you appointment. Set at rest is that the issue gets a quietus, decent burial of the matter.
my lord.
Now, what can be done?
My lord,
Notwithstanding the fact that this is great harm to all those persons who were selected but
Wow.
not appointed. But then it should have been pursued after 2000.
no, we did pursue.
You did, but after in 2004, 2005, 2008, and there were various orders with different orientation.
My lord.
Nothing could have been done. Those orders, I mean, in our estimation, ought not to have been passed in a general way. In fact, a committee should have been constituted earlier. And then we don't have the records. You are not able to produce any records naturally because you are only an aspirant. But in such circumstances, can there be an order or a mandamus by the court? And when 25 years have gone by, you would have applied when you were 25 years of age. Below that, you could not have applied.
My lord.
Correct. So even if you had applied at the lowest threshold age,
My lord.
you would be around 45 now.
Lord, our fresh medical examination can be done, my lord.
Why that exercise? In under which power? You can,
My lord,
you have
the-
the option to seek, compensation or whatever. We can't do
My
anything.
lord, what my respectful submission, my lord, is that, my lord. My lord, admittedly from the records or the various.
There is nothing admitted here. Don't say
No, my
admitted.
lord,
It's
the-
your case.
Admission of our selection, that is, my lord, what I am respectfully back
That's a
to.
statement which is not supported by anything on record.
No, no, my lord, the affidavit, my lord, which the state has filed, my lord, in that affidavit, they have admitted, my lord.
What will they do?
My lord, they have admitted affidavit in opposition, my lord, filed in this petition, my lord, may be pleased to find that opposition is at page 4 to 5, my lord.
They understand it differently.
My lord, that affidavit starts at page 4 to 5, my lord.
Nothing can be done, sir.
My lord, may I pray, my lord, that I have just,
As directed by the earlier bench,
my lord.
sometimes in the past, the matter should be set at rest.
My lord, then, my lord,
Already have found your vocation in life.
my lord may be pleased to set the same on rest, my lord. After the vacation, my lord, I will try to satisfy with some judgments, my lord.
No.
Some-
Keeping this petition
No,
pending
Lord,
with
with-
respect to an advertisement of 2000.
No, my lord,
We
my
are
lord,
not-
at least one chance may kindly be given, my lord.
What will you say, Mr.
My lord,
Bhuyan?
I will produce some judgment.
Look,
for
I am
satisfaction.
always ready to accommodate the lawyers
My,
for
that is correct, my
as
lord.
grant of time is concerned, but
No, my lord,
here
only,
nothing can be done.
only one chance may be provided, my lord. My humble my request, my lord. Life of 427%.
The 427 persons all right, but we have to see both ways, no?
That is correct. my lord.
Unnecessary pendency, you
No, my lord, I am just seeking
Mr.
for
Bhuyan,
today's accommodation only, my lord.
we will grant you.
My lord.
But keeping this pending gives a kind of a lease of life to these petitions which have already died. You are whipping a dead horse.
No, my lord, the last judgment, my lord, which.
No judgment is required. This could be disposed of just in one line that for whatever reason.
My lord.
Now, advertisement of 2000, several vacancies, several years, it
My lord,
was all
that is-
filled up. Nothing was done with respect to you.
But my
do
lord,
not
we
take
are,
up
we
this.
are, we are not sitting idle, my lord. We are continuously pursuing, my lord. Just one chance, my lord.
Wrongly advised. Wrongly advised.
No, my lord, from 2000, my lord, then these events started, my lord. One chance, my lord, after the vacation, my lord.
But then I don't think you have the only fact which we are concerned with is it's an advertisement of year 2000.
That is, my lord, I cannot deny, my lord, that is a.
Where would you be accommodated?
My lord, supernumerary post can be created, my lord.
How, what do you say? 407 are
My
we
lord.
sitting here as
No,
kings
my lord,
of
the
some
state, my
kingdom
lord,
or
for
what?
the, my lord, for the purpose of provincialization of answers, my lord, teachers, the government has created more than 4,000 posts, my lord.
Can you draw a parallel there?
No, my lord.
This is what you will conceive of during all these days when the matter will be listed again.
My
Those arguments are not tenable.
my lord, after the vacation, I will try to satisfy, my lord.
Let us satisfy you at least.
My lord.
We can't do anything for these
Well,
407
I know,
people. Let's satisfy you at least. Take them. We have heard Sri Bhuyan, learned advocate for the appellant. The issue arises out of long-standing grievance of the appellants because they were not appointed as constables under the Assam Police Battalion, despite having applied for the same pursuant to an advertisement dated 17/1/2000. Their claim is that they had participated in the recruitment process and were duly selected as well. However, no appointment letters were issued to them. They preferred a writ petition before this court seeking redressal of these grievances, their grievances. Several writ petitions were later filed with the same prayer. In many of the writ petitions, directions were issued that the cases of the appellants ought to be considered in accordance with law. Nothing happened. And however, thereafter, two writ petitions were filed, namely WPC number 905 of 2008 and WPC number 1135 of 2008, seeking mandamus, seeking directions for their appointment. Those writ petitions were dismissed way back in the year 2009 on the ground that the appellants had failed to produce any document confirming their selection. There were no records available in the office. And the reason being that according to the police manual, the records were destroyed after some time. It appears that because of the sustained efforts of the appellants, a fact-finding committee was formed pursuant to an order passed by this court in one of the proceedings. The fact-finding committee opined that the claim of the appellants may not be totally unwarranted and required to be considered at the appropriate governmental level, given the destruction of the records of the entire process of recruitment and selection. Thereafter also, no action was taken, leading to lodging of another writ petition, filing of another writ petition, namely WPC number 3426 of 2020, with a limited prayer of a direction to the concerned authorities for consideration of the representations which they had filed before the authorities. In this instance, an order was passed by this court directing the authorities to consider the earlier representations of 2012 as also the new representation, along with a fresh statement of facts to be filed by the appellants. The appellants, in their endeavor to keep the case alive, keep the claim alive, filed a fresh representation on 21/2020. Based on these representations, the respondents passed a speaking order on 19/4/2022, rejecting the claim of the appellants. The aforementioned order dated 19/4/2022 was put to challenge before this court, before the High Court, by WPC number 3092 of 2023, which too was dismissed on 19/4/2024. So hence this appeal is a separate line, apparently. Hence this appeal. So, Mr. Bhuyan, learned advocate, has submitted that notwithstanding the absence of formal selection records, once it was admitted by the respondent authorities that the appellants had participated in the selection process and a fact-finding body constituted by the orders of the court had recommended for consideration of the cases of the appellants, their claim ought not to be rejected lightly, even though 25 years have passed by. He further submitted that destruction of selection records cannot be a justifiable ground to deny the appellants their claim. The appellants, it has been contended, have been dealt very unfairly. The appellants have not sat over their rights, but the inaction was on the part of the state and the police administration in addressing their claims, which needs to be addressed. We have gone through the speaking order, which was put to challenge before a learned single judge. The order referred to above lists the number of times that the issue fell for consideration before the authorities, as also the court. But it was not possible now to direct for appointment of the appellants on the post of constables. Several recruitment processes were conducted from 2002 onwards, but for some reason or the other, the claim of the appellants could not be substantiated. Could not be substantiated. It was also noted in the order referred to above that this High Court in WPC number 720 of 2021 had passed an order on 24/5/2004 that the matter should be allowed to set at rest and be not carried any further. Even then, at the instance of the appellants and others, despite that, the claim of the appellants were considered, but was found to be not tenable, especially due to passage of time, destruction of records, and taking into account the fact that any appointment now, after 25 years of the issuance of advertisement, would be beyond the provisions contained in Assam Police Manual Part 3, which mandates that only strong and healthy young men between the age of 18 and 25 should be recruited on the post of constables. The further assessment of the Inspector General of Police Administration, under whose signature the speaking order was passed. Most of the appellants would have crossed the age of 45 years. And therefore, any consideration regarding their claim for appointment, regarding their claim for recruitment on the post of constables would be beyond law and the rules. Mr. Boyan, while we were about to conclude this case, Mr. Boyan sought another time to canvass his case, considering the fact that this case relates to the appointment process of the year 2000. We were initially reluctant to accede to his request, but on his insistence, we adjourned the matter with the caveat that on the next date, no further adjournment shall be granted to the petitioner. List this matter for hearing, not for hearing, list this matter under the same heading on when do you want?
After vacation,
Do you really want to contest this now?
my lord,
We are sorry to say this. I mean, we are those unfortunate 460 persons, but nothing can be done about it. It has to be set at rest now. You really want, then we adjourn the matter on that.
well, one chance, my lord, some judgment.
So. Whereas on that day, nothing much will be required. to
It
be
is
said.
already recorded.
My lord, in
Obliged.
the cause list, my lord, respondents column is blank. My lord, lordship may directed to, my lord, reflect the
Show the
name of
name of
woman
JS.
advocate.
Let the name of so-and-so be printed in the cause list. Let the name of so-and-so for respondents be printed in the cause list henceforth.
2410,
Obliged, my lord, highly obliged.
item number 3.
Hello there. Hello. Lordship, in this PIL, we have filed 2 affidavits and the petitioners, they have filed 2 replies. We have said that some work have been done, but they are disputing. Now the chief engineer has taken up the matter and he has directed the SE, superintending engineer, to conduct an inquiry.
What has happened? Please let us know. We don't-
Executive engineers affidavit.
No,
we
no,
have-
what is this case about?
The case is about construction of 3 roads at South Salmana Mankacha district.
Yes,
We have filed 2 affidavits stating the status of the construction work,
yes,
but the petitioners by filing reply, they have disputed.
yes.
And in fact, in the second affidavit also, we have shown that 2 roads we have completed and in third road, some work is still left.
Which has been doubted by the petitioners.
They are doubting and they have also given some photographs. We have taken up the matter. The chief engineer has now taken up the matter and directed the superintending engineer to conduct an inquiry and submit a report. Kindly give us 2 weeks time, my lord, let the report come. Otherwise, my lord, we are ready. They will do the work, my lord. They are doing the work and they will see.
Mr. Deenath, learned counsel for so-and-so, seeks 2 weeks adjournment
Lord,
to bring on record the report of the inquiry
Lord,
constituted by the chief engineer.
Lord,
Report of the inquiry at the instance of the chief engineer
my lord.
with respect to non-completion of the project of construction of 3 roads, which was scheduled to be completed by March 26, 2024. The allegation of the petitioner is that the respondent number 8, the contractor had sublet the work to respondent number 9, and the claim of the respondents of having completed the 2 roads and the and 90% of the third row is factually incorrect. It has also been brought to the notice of this court that the assistant executive engineer, bracket respond number 6, never objected to the payment of rupees 1 crore for the work that has not yet been started. Apart from the difficulties faced by the pedestrians, there is an allegation of severe misappropriation of public funds as well. Let the report let the report of the committee, let the report of the inquiry be placed on record on the next date.
Mal.
Re-notify or give a date in October. We give you more than 2 weeks, but please see something concrete is done.
Yes,
It's
yes,
not the way you.
Not, they have taken up.
You should have taken action against respond number 8.
But the
Anyway, let's see.
authority.
We are not interested in any action taken. We want in the action
the work-
taken with respect to construction.
Construction, that's true. That is the ultimate.
All right.
Logic.
2017. Item 4 and 5.
Yes,
May it please your lordship. Lordship, this petition challenges an advertisement and a rule of the APD made under their articles of association. Regarding lordship, page 19, lordship, I'll point out the 20 is the provision, the educational qualification. Lordship, the second bullet at 6, full-time diploma course in engineering,
where are you reading?
page
Page 19.
20, serial number 6.
No, you have to start from the first page, Assam Public Service Commission. It says what?
It's
Invites
a-
applications from as defined under 5.
For the post of junior manager electrical.
Mentioned for post. Yeah, what is AP, Assam? What is AP? What is AP? Assam Power Distribution Company. Yes, for junior manager electrical.
Junior manager electrical. The petitioners are diploma holders.
No, but
Ele-
let us see the advertisement quality. Are you concerned about the eligibility criterion for applying?
Yes,
You have to say that, no?
I'm the educational qualification. We are diploma holders. It requires diploma hold.
Whatever you are, that comes later. Let's see the advertisement first. You're questioning the advertisement
And the rules, lordship,
and the rules.
rules.
So let's see the advertisement first, thereafter rules, and then your qualification. Educational qualification for junior manager electrical full-time diploma with minimum 60% marks. Oh, you are aggrieved by this
Yes.
benchmark of 60%.
60%.
And this is pursuant to which rules?
Yes, lordship, at page, it starts from
In fact, you should be leading the bench and not the bench leading you.
page 28, lordship, it's rules. Page
28.
28, it's called the APDCL Junior Manager Service Rules 2012. Assam Power Distribution Committee Limited Junior Manager Service Rules 2012.
Please question that. Rules framed in exercise of the powers conferred by Article 76, 76T of the AOA Articles of Association. All right.
Before I, lordship, go to the offending rule, lordship, I'll just point out the, at page 29. Roman section 2, Roman 16, the definition of junior manager. Means a person appointed to the service as junior manager of a company who has passed at least high secondary living certificate examination of the board of secondary education Assam or any examination recognized by the government as equivalent thereto, and who possesses 3 years diploma electrical civil instrument electronics computer science engineering and telecommunication engineering from any institute recognized by the government.
So this is the minimum qualification.
Qualification.
There is no stipulation of 60% marks in
60%.
diploma.
That I wanted to show.
So the rules only say this.
Now at page 31, Lordship, rule 8, qualification for direct recruitment. A person shall be appointed to the service by direct recruitment provided he holds a 3-year or 4 years diploma in respective branches of engineering by the electrical, mechanical, instrumentation, electronics, information tech, computer science, engineering, telecommunication, civil from government recognized institution, provided that candidates secure a minimum aggregate of 60% or its equivalent for being eligible for admission into the written test, 50% or its equivalent in the case of scheduled caste or scheduled tribe candidates. Therefore, Lordship, what I am aggrieved of, it deprives me of the right to consider even for sitting in the written test, Lordship.
And what grounds do you, these are policy decisions, no? A higher benchmark, only the employer would know whether it is required. Let's see their response to the, what have they said? Mr. Goswami,
Well,
take
paragraph,
us to that paragraph.
yes, madam.
It's a very high benchmark, agree.
Two, madam.
That also for the purposes, whether you require, I mean, whether high marks in diploma is correlated to the efficiency. That's the question which you would ultimately raise.
Yes, madam.
But then can it be questioned now or ever if the policy decision is such? But
Yes.
these are rules under the Articles of Association.
Madam.
It must conform to Article 14 and 16. Those are, but let's see what's your response.
My lord, paragraph 5 of my affidavit that I filed on, my lord, 6/1/2025.
That's the only affidavit here.
Yes, my lord. Paragraph 5 and my lord,
Read.
paragraph 5, that a deponent begs to state that the article of association of the Assam Power Distribution Company Limited, hereinafter referred to as APDCL, empowers the board of directors to frame service rules governing the condition of service of the employee in different service such as engineering, finance, accounts, human resource, etc. The board of directors of APDCL in its meeting held on 15/10/2012 by resolution 19 approved the APDCL junior manager service rule. Thereafter, the same was notified on 22/11/2012. Rule 8 of the said rules provides for direct recruitment of junior engineer who have passed diploma in examination with aggregate marks of
That's
60.
all right. Come to paragraph 6. Well, that's something.
Yes, madam. That a deponent begs to state that APDCL Junior Manager Service Rule 2012 having been framed under Article of Association, namely Article 76(3)(t) of the AOI, is legally valid as APDCL being instrumentally has the power to frame its own rules for recruitment of so and so. Moreover, the recruitment rules that are framed by the APDCL are consistent with Article 14 and 16 of the Constitution of India. APDCL have prescribed the qualification to the extent of 60% marks in diploma for admission into written test for the post of junior manager as laid down by the APDCL Junior Service so and so. And the same is done under the proviso to Rule 8A. The proviso to Rule 8 is eligibility criteria, and the same has been incorporated in order to empower the APDCL to recruit meritorious candidates, and more particularly those candidates who have performed well in their diploma examination. It is otherwise a well-settled proposition that the law that the employer is the best qualified to lay down the eligibility and essential qualification of employment and the basis of its needs and recruitment. If we, my lord, come to paragraph 8 again, 8, my lord, that the answering deponent states that begs to state that the petitioner has failed to unable to show cause proper grounds as to why the junior manager service rule in 2012 is in violation of Article 14 and 16 of the Constitution. The prescription of 60% as minimum marks for appearing in written test has reasonable and rational nexus for the purpose of recruitment of junior manager in APDCL.
the reasonable and rational nexus is that by prescribing 60% as marks, minimum marks, the respondent company would be able to recruit best and meritorious candidates for their company. The APDCL being the services of providing electricity cannot compromise in the quality of service or providing electricity as it is an essential service. Well, assuming, my lord, the minimum marks was 55. In that situation, my lord, persons obtaining less than 55 would also have come and said that we are agreeing. So there is no end to it, my lord. Yes, it is a classification, but it's a reasonable classification, my lord.
Now, the question is that the proviso to the rule, could it nullify the effect of the main rule? That's one question.
True.
Number two, it is not always, I mean, that's not for us to decide. We are not repository of all wisdom. The employer, which is a statutory body, and the rules have been framed, it's an instrumentality of the state. The rules have been framed according to the Articles of Association under the power. So the competence to frame rules has not been questioned. Now we are only thinking aloud, but 60% first division, 60% if first division in diploma. I mean, that is a benchmark for even permitting people to appear.
Yes, correct.
How many of you successful advocates have 60% all through? Mr. Chaudhary, you must have been the topper. Let me ask.
I got around 58, my lord.
I
got
don't
around
have.
58%.
I have.
How many people get
Second class.
60%? Don't think about present day marking where people get 99%.
Mhm.
And admission in some colleges ends at 100%.
Yes.
That's a new marking system.
True, my
But
lord.
then is it not very high?
In fact, my lord, other agencies like my lord, Oil India, ONGC, they're also doing that, my lord. There I have annex, my lord. In my
That's a ground that you can take into account that
But-
we can consider.
paragraph
Where is
9,
that?
paragraph 10 is my lord premises, madam. Page 67. Well, if we turn to paragraph page 68, my lord, my affidavit.
Yeah.
At the bottom of the paragraph, my lord, line starting around 9 from the bottom, with the sentence, with the word moreover, similarly placed. Government instrumentalities like ONGC, Oil, Department of Atomic Energy, Assam Engineering Service Recruitment Board, in their advertisement of recruitment have also prescribed minimum percentage of marks.
But
for
minimum percent is what? Minimum percent is 50, 55. Less than 60 is on a very high level.
My lord, may kindly peruse, my lord.
Tested them. See, the rule says that they must be diploma holders.
True, my lord.
Now, this sub-classification, doesn't it make the whole process more onerous for candidates? You're blocking, but you have been getting candidates.
Yes, but in fact, my lord, what I say, my lord, perhaps for the purpose, present day, my lord, this petition has become infrastructure. We have already conducted the selection, there is no stay, and already to
This questioning the rationale of the rule.
true.
Therefore, it doesn't become interactive.
To that extent, otherwise not, my lord, but they are intent to participate in the selection process. That selection process is already over. People have joined, my lord. In all the posts.
And you got people more than with.
Yes, my lord.
Naturally, they would
Yes,
have
my-
only participated.
We have, my lord, at page 78 of my affidavit, entire select list I have annexed, my lord. Total 215 posts were advertised, 215 posts filled up, my lord. With persons obtaining 60% as.
Are you thinking of future, Mr. Bora?
Yes, Lordship, prayer number 1 at page 14 is a challenge to the rule. Prayer number 2 is
Why do we see it unless it is required?
Lordship,
Now,
again,
that issue is gone, and we have Supreme Court decisions which say that don't question the legality unless it is very pressing.
Lordship,
You have lost that chance.
Lordship, before, after the selection advertisement was done, we have directly come to that board. Lordship, it is true that there was no interim order.
With that recruitment process, we can't do anything. You can't even claim any.
Lordship, now,
Yes. That's out of question. Now, therefore, you'll have to limit it to the rationality of the rules.
rules. Yes,
And
Lordship.
testing it on the annual of 14 and 16.
Yes, Lordship,
The
there.
difficulty is this. Now, all similarly placed government instrumentalities, ONGC, Oil India Limited. What is it? Oil India Limited. Atomic Energy, Assam Engineering Service Recruitment Board. 60%, and not for the entire academic career. They would require it only for the diploma, which is the basic qualification for you to become a junior manager.
Yes, Lordship, at page 48, we have also, from page 48, Lordship, at page 49, 50, we have also given some examples of recruitment process. That is APSC recruitment process at page 48. Lordship would see that at page 49, name of the post, Assistant Director of Cottage Industries. Serial number 4, a candidate must have bachelor degree in any branch of engineering or arts or university of any other institution or abroad recognized by the government for purpose of minimum second-class honors measure. Now at page 50, again, assistant engineer. Again, it is only bachelor's degree. Now at page 51, junior engineer, which is with equivalent. The educational qualification is 3 years diploma in engineering, mechanical, civil, electrical. That is Assam Public Service Commission. Lordship, my ground is that a person with 59% would not be eligible to be considered for appointment, whereas 60% would be. Now there is no reasonable nexus between the objects sought to achieve. Lordship, I have enumerated the functions of a junior engineer. They have in their affidavit has not said where a person of 59% cannot do, but a person of 60% can do. Lordship, the job qualification has no reasonable nexus with the object sought to achieve.
Tell me, Mr. Bora, who decides it? The employer. Unless it is manifestly arbitrary. You're right, we are with you so far as that is concerned. 60% would not be directly proportional to the merit or your performing abilities. We understand that. But say, had it been 70%, I mean, how low could it be brought to? 50% also would be higher.
Lordship,
Suppose you were a diploma holder, the requirement is that you should have a diploma. So diploma pass marks is 40 or 35, not 40. No, pass marks is 50. For a diploma, I think the pass marks everywhere is 50, right? In any technical organization, that's what I know from my experience. So 50%, so they have set a higher benchmark of 60.
yes.
So that is permissible. You are aware of the law with respect to that,
Yes, Lord.
KK Jyoti versus State of Kerala, then Trilokinath Khosla. These are judgments which say that the authorities can settle a higher benchmark.
Yes, true, Lordship.
Unless it is manifestly arbitrary. They're not asking for distinction. They're not asking for 75%. 62, my understanding, it is very difficult for a student of average caliber to get 60%. But they have been getting people, no?
May please.
The post is filled, there are no vacancies, and there can be some parallel. We must have- It's a big pool.
May I just point out one thing?
That I don't
Hey,
know, but 250
Lordship,
were selected.
Anyway, let's conclude it. It will be difficult for us. Who
Lordship,
decides it?
Lordship, one thing, but that is one thing, Lordship, the employer decides it, but the employer cannot decide it in a manner to nullify the main provision.
So therefore, my brother was asking this question. In one of the cases before Supreme Court, an exercise was done to find out whether the rule would exclude the vast majority. Now, suppose High Court is asking for application for the post of, say, assistant, keeping, the benchmark at 75% in graduation or 75% in some court, and they don't get many. Posts are 100, they get only 5 or 10. Then perhaps the higher benchmark excludes the vast majority and therefore manifestly arbitrary. Can you show that?
Yes, Lordship, if it is lower, suppose second class, then that is
Larger-
competition would be better.
That is not the consideration here. We understand that's this argument would be misplaced in this circumstance. So can you demonstrate that because of this higher benchmark, vast majority of such aspirants have been excluded unrationally? You can't
Lo-
The
Lordship,
only argument that you can make, I'm arguing for both sides, Mr. For
Yes,
only for the
Lordship,
reason of
obliged.
clarification in my mind.
Uh.
So you can say that without any empirical, finding, they should not have placed it higher. But then this argument cannot be stretched beyond a point.
Lordship, that thing, Lordship, for that reason, from statistics, I have to show it. At least from the, so
You
Lordship,
will not be able to show it for the reason that their posts have been filled.
but if I can show what Lordship, has asked that if
Then perhaps
leaves
you
the vast
will
majority.
lose immediately diploma holders are having much, much higher marks. You must not be a good student. You can.
Lordship will.
Present day. Anyway, let's conclude. No, we don't
Lordship,
have-
just one opportunity to show that the vast majority
No,
has
no,
been
no,
left
no.
out.
That is evident from the fact that appointments have been done.
Examples of other organizations, my friend. They are all insisting on 60%, even in case of law officers. Assam Engineering Service Recruitment Board, second page, my lord, qualifications. So and so BTech, BE, BS, with first class or equivalent.
More than 60.
These are 4 organizations, my lord. All are insisting on 60%.
You have made a-
Lordship, what I am on is that, it deprives even for the right to consideration for appointment, therefore.
And why should we hear on the constitutionality of it when the whole claim has become in fact? Why do we get into it?
If the
Nonetheless,
rule
it
remains,
is-
Lordship, if the rule remains, Lordship, future also, Lordship, will be barred from appointment, Lordship. For that reason, Lordship, Lordship knows the law, but Lordship, for just I wanted to place 2 judgments in this regard.
Will you give us? And please don't have this illusion that we know the law. We are required to be told the law. Yes, give us the judgments.
That is one.
1962 AIR, 1962 SP 303.
Take us to the relevant paragraph.
Yes. Basically, there was a ban on appointment 5, para 5 last place. It is clear, therefore. And therefore, that
Which judgment are you reading?
1960 AIR 1962 SC 603. It is clear, therefore, that the petitioner has been deprived of his constitutional right of equality of opportunities in matter of employment and or appointment to any office under the state contained in Article 16(1) of the Constitution. So long as the ban subsists, any application made by the petitioner for employment under the state is bound to be treated as waste paper. The fundamental right guaranteed by the Constitution not only to make an application for the post, but the further right to be
This is
considered.
with respect to a ban imposed upon an employee to be ever taken into the government service.
Yes.
You can't equate it with this. No,
Lordship, because of this 60%.
no, not 60%. Look at
No,
this.
Lordship is correct, but what I wanted to make my point is that because of the 60%, I would not be able
Yes,
to
tell us about
apply.
the second case. Let's conclude it. No.
Lordship, this case, 2008 3 SCC page 1.
Anuj Garg.
Yes, Lordship, the Punjab rules 2008 3 SCC page 1. It restricted women from working.
This is again another thing. Adverse circumstances faced by women in employment avenues.
Lordship, para 25, I
State.
wanted to point out only that the right to consider for appointment is a fundamental right.
If have 60%, you'll have a right to be considered benchmark. I mean, right to be considered is what? A non-diploma holder, can he come and say that, appoint me? I have better practical knowledge.
Lordship, only thing, Lordship, I wanted to pray right now, if Lordship is not seeing this matter because the facts are gone, then Lordship.
That we have said that we still will decide. We still will decide. We could have shirked away from deciding it for the reason that you've lost the chance. And we don't see any rationality of questioning the constitutionality of the act. But we'll do so. we are with you so far as 60% is on the higher side. We understand.
Yes,
But then we can't sort of strike it down. That is for the employer to decide. It's not manifestly arbitrary. It's not manifestly, that's the reason. Otherwise, okay.
Lordship,
Take-
the test of arbitrariness, Lordship would decide on the fact that if most of the diploma holders doesn't have 60%, Lordship.
The argument we have already said. How many times would you want us to repeat that? We have heard Sri B.P. Bora, learned advocate for the petitioner, and Mr. P.N. Goswami, learned additional AG, Assam, assisted by Mr. K.P. Pathak, standing counsel, APDCL. The petitioners who were aspirants for the post of junior manager electrical in Assam Power Distribution Company Limited, hereinafter called APDCL. Which post was? Kalika, how I said? Advertised on 30/3/2023, but they were denied the opportunity of appearing in the recruitment examination for the reason of their not having 60% marks in their diploma. The restriction apparently flows from the Proviso to Rule 8 of the APDCL Junior Manager Rules 2012, which prescribes that only candidates who have secured a minimum of 60% marks in the diploma would be eligible for admission to the written test. The claim of the petitioners is that even though otherwise they are qualified, as they have a diploma, but they stand excluded from consideration solely due to percentage criteria. The major contention of the major ground of challenge put forth by the petitioners are that 60% eligibility condition is arbitrary, unreasonable, and without rational basis. There is no reasonable nexus between securing 60% marks in diploma examination and the efficient discharge of duties as a junior manager in APDCL. There also does not exist, it has been argued, no intelligible differential between candidates who have scored 60% and those who have scored below, because both categories of aspirants would be holding the same diploma qualification. Considering the fact that the recruitment process against the advertisement of 30/3/2023 is over, the petitioners now have chosen to challenge the constitutionality of the APDCL Junior Manager Service Rules 2012. Mr. Bora, learned advocate, has drawn the attention of this court to the rules which have been framed in exercise of powers conferred by Article 76, bracket capital T, of the Articles of Association of APDCL. A junior manager has been defined in the rules as a person appointed to the service as junior manager of the company who has passed at least the high school leaving certificate examination of the Board of Secondary Education Assam or any examination recognized by government as equivalent thereto, and who possesses at least 3 or 4 years diploma in electrical, mechanical electrical slash mechanical slash civil slash instrumentation slash electronics. We'll take it from page 29 of the brief. Instrumentation slash electronics slash computer science and engineering slash telecommunication engineering from any institute recognized by the government. There is no prescription here of a diploma holder having acquired 60% marks. However, in Rule 8, which specifies the qualification for direct recruitment, comma, it has been provided that a candidate securing a minimum of aggregate marks of 60% or its equivalent in 3 years or 4 years diploma in the respective branches would only be eligible for admission to the written test with 10% relaxation in case of scheduled caste and scheduled tribe candidates. While challenging the constitutionality of such prescription for a candidate at the threshold to be able to appear in a recruitment process. It has been argued that it is a classification beyond permissible limits, making a subcategory of persons who have not scored 60% in diploma, who would stand excluded. With this prescription, a vast majority of aspirants would stand excluded. The sheet anchor of the argument of Mr. Bora is that such prescription is not reasonable by any standard. And it also does not have a reasonable nexus with the technical staff quality which any employer would look for. First off, it is a rigid percentage benchmark creating a sub-classification within the diploma holders, which is neither required nor warranted. Stop. Academic marks do not necessarily correlate with efficiency. Stop. If the employer desires to take in service only meritorious candidates, it is not only the marks which is important, but the practical experience and the practical experience and the otherwise, and the practical experience and the capabilities of the aspirant who has the basic qualification, namely a diploma, which is the minimum required qualification for being appointed as junior manager of the company, junior manager of the company. Mr. Goswami, Learned Additional Advocate General. While animadverting to the aforenoted arguments, has submitted that this falls in the domain of policy of the appointing authority, which ought not to be questioned. Fixing a benchmark of minimum of 60% in diploma is quite rational and in accordance with the prevalent prevalent requirements, prevalent practice in other government companies, and is definitely not arbitrary. Fixing a higher benchmark which is unreasonable could be objected, but asking for 60% of the minimum marks for a candidate to appear in an examination is directly relatable to the object of recruitment of meritorious persons. It is only to ensure merit and not for excluding people. So the very fact that the recruitment process, which started with the advertisement on 30/3/2023, has been successfully completed with many aspirants having participated in the said process, it cannot be said that the prescription is too onerous, impacting the exclusion of a vast number of such diploma holders. The claim of the petitioners, therefore, Mr. Goswami asserts that a large number of people would be excluded because of this higher prescription in the rules is based on no empirical justification, is based on no empirical founding, based on no empirical study. On the contrary, it has been pointed out that similarly placed government instrumentalities like ONGC, OIL, Department of Atomic Energy, and Assam Engineering Service Recruitment Board, in their advertisement for recruitment, have prescribed minimum percentage of marks on the higher side for appearing in examination. After having heard the learned counsel for the parties, we find that the Articles of Association of APDCL empowered the Board of Directors to frame service rules governing the condition of service of its employees in different services, including engineering service. The Board of Directors, in its meeting held on 15/10/2012, approved the APDCL Junior Manager Service Rules of 2012, which was notified. Since these rules have been framed by a valid process, and APDCL being a state instrumentality, having the power to frame its rules for recruitment, the constitutionality of such rule does not remain questionable. The prescription of minimum of 60% marks in diploma is though on the higher side, but it cannot be said to be inconsistent with Article 14 and 16 of the Constitution of India. True it is true that such decisions are in the domain of policy making, falling in the realm of the powers conferred on the Board of Directors of the instrumentality. Unless it is shown, unless it is shown that the prescription in the advertisement is manifestly arbitrary or having no reasonable nexus with the object sought to be achieved, normally such decision making is not required to be interfered. Is not required to be interfered. The judicial precedents justify valid classification for higher educational qualification, valid classification of higher educational qualification, and the rule-making body could set a higher standard for the recruitment, as only the employer knows what is required of its employees. in Sanjay Kumar Manjul versus Chairman UPSC and others, 2006, 8 SCC 42. The Supreme Court has held that the qualifications for recruitment to a post are laid down in terms of the statutory rules. First off, the statutory authority is entitled to frame the rules laying down the terms and conditions of service, as also the qualifications essential for holding a particular post. First off, it is only the authority concerned which can take ultimate decision thereof. The jurisdiction of the superior courts, the jurisdiction of the courts, it is tried, would not be to interpret the rule, would be to interpret the rule, but not to supplant or supplement this. It is well settled that a court, while exercising its jurisdiction under Article 226 of the Constitution, ordinarily would not direct an employer to prescribe a qualification for holding a particular post. Similarly, in Chandigarh administration to the Director Public Instructions, bracket colleges, Chandigarh, versus Usha Chhatrapal, WAIE, Chhatrapal Y, and others. It has been categorically held that courts can neither prescribe qualifications nor entrench upon the power of the authority concerned, so long as qualifications prescribed are reasonably relevant and have a rational nexus with functions and duties attached to the post and are not violative of any provisions of the Constitution. A higher benchmark of 60% in diploma cannot by any standard be said to be arbitrary or exclusionary, especially when such higher percentage is prescribed for recruitment in other government agencies. So from that apart, we further reiterate, even at the cost of repetition, that in the recruitment process referred to above, the respondent corporation, the respondent corporation did not face any dearth of applicants, and the process was successfully conducted. This is illustrative of the higher prescription / benchmark for appearing in the recruitment process, or appearing the recruitment examination. What have I said last time? In this instance, a higher benchmark is not at all exclusionary, thus finding that the rule conforms to Article 14 and 16 of the Constitution of India. We do not find any merit in the challenge to the rules as being violative of the provisions of the Constitution or being too onerous. The petition is dismissed.
Supplementary list, item 19 and 20 for orders, along with item 11 and 10.
What is this for?
My lord, the matters relate to the e-court services.
Which services?
E-court services. my lord.
Court services. Are we getting some matter here? I can, take up people.
My lord, on last occasion, when it was pointed out that the claim of the petitioners and in respect of the proposal sent by this honorable court was rejected, such as this
Let
rejection.
us take it up along with 10 and 11. We'll take it up along with 10 and 11. All right.
What I,
What is your prayer?
at present, my lord, the last communication which was made by this honorable court to the judicial department on 30th/7/2025. In the meantime, we filed this to interlocutory applications for amendment of the writ petition, bringing those records. Now it seems another order has come. So as on the instruction of my senior, Mr. K. N. Chaudhary, he said, my lord, only thing to make a prayer before this honorable court that we will withdraw and all the writ petitions, in this case, everything, with the liberty to file a fresh writ petition
That's good.
so that we can.
In the
incorporate-
meantime, there are two impugn orders, my lord. One already served.
All right.
On
So-
2nd September, there is
That's right.
another.
So you withdraw these two applications and 10 and 11.
Yes, and with the liberty to file
Because
a fresh.
after these two orders, my lord, there should have been change in the pleadings also and the line of challenge also, my lord. So that's why.
Again, what's your name?
J. Abedin.
Mr. J. Abidi. We have given this. Mr. J. Abidi. Mr. J. Abidi. Learned counsel for the applicants seek permission to withdraw these applications as the writ petitions or the writ petition as WPC number 4429 of 2021 and WPC number seeks to withdraw WPC number as Pura Katlo, Mr. Abidin Learned Counsel seeks to withdraw WPC 4429 of 2021 and 4389 of 2021. And the aforementioned two interlocutory applications, namely so and so, in order to enable the petitioners to approach this court afresh, which has been necessitated because of certain orders passed by the judicial department of the government of Assam.
As well as the finance department.
Judicial, as well as of the finance department, dismissed as withdrawn with the liberty aforesaid.
Highly applicable.
Supplementary list, item 21 for admission.
For 4 and 5, both the petitions have been heard to that. No? Item? Yes.
Maybe.
Talukdar.
May please, your lordship. My lord, it rests on a very short campus. The petitioner one, my lord, is a proprietorial firm. And the two, my lord, is the proprietor who represents the petitioner one. And the respondents one, my lord, it's a public finance institution under the Companies Act and has been registered with the RBI as non-banking, my lord, financial company, NBFC. Now, what has happened, my lord, in 2019 and 20, the petitioner, my lord, he avails certain loan that is amounting to 1 crore 18 lakhs to start, my lord, the spice industry. And thereafter, regularly, my lord, he had been paying installment. But due to reason beyond his control, in fact, my lord, the industry was
Surface proceeding initiated.
my lord, not surface proceeding initiated, my lord.
Yes.
Thereafter, my lord, in fact, the possession notice, my lord, of the magistrate 23/8/24 was challenged, my lord, by the petitioner before the DRT, saying that the requirement of notice under 13(2) that was not served, giving 16 days, my lord, to pay the default amount. Now, this plea was rejected by the DRT. Now, the position rests, my lord, as on date, my lord, in fact, the petitioners, they want to take back the property by paying, my lord, whatever amount is due. My lord, in fact, out of 101 crore 18 lakhs, the petitioners by this time have paid about 60 lakhs, 50% of the
No, that's
principal
all right. That
amount.
quantum, we are not concerned.
My lord.
You want to redeem.
Redeem the property,
So is there a sale notice?
my lord, not yet.
Not yet.
Yes.
It can be.
Yes.
13.8.
That's
13.8, yes.
13.8, my lord.
13.8.
That we have made a statement.
You're not agreeable to it. No, 13.8 is, we have not issued. They can avail. But the problem is that they are asking for settlement. The value of the property is higher. No. That settlement, that OTS scheme is, you have to redeem it. And therefore, you have to pay the cost and everything. That's the rule. Yes. It specifically
That's
states. It says that it's a protection to you, but it says that dues plus cost plus charges plus expenses.
Correct.
I mean, you can't just, if you give an undertaking, we will stay. There'll not be any sale. There'll not be issuance of any sale notice or auction notice. You take instructions, tell us if you're ready to pay everything. The protection comes to you only after the amendment of the
Correct.
section, after it is 2016 or
16, my lord, 16. 16.
So that's a limited protection to you
Correct.
to redeem. So take instructions. If you say that, here we will record it, we will state.
Correct.
But not OTS.
We are-
Because otherwise you need to go before the respondents. If they are agreeable, all right, why would they not be? Why would they incur further cost in litigation and face, suffer charges? They would do, you would have asked for your one-time settlement. 13.8 is not for one-time settlement.
Correct. My lord, we have in page 50.
Otherwise, that Satyavati Tandon would apply. Let us keep our.
Correct. My lord, in page 56, my lord, we
No,
have.
that's one thing. I mean, you take instructions, come back to us, otherwise we dismiss the petition. And do whatever you wish to.
Yes.
But if you're ready to pay the dues plus cost plus charges plus
Correct,
expenses.
under 13.8, correct. My lord.
13.8 is clear, no?
Yes, clear. That is clear. My lord, we are asking for a notice at page 56, my lord. Let them, my lord, have a discussion with us, my lord, whatever we can pay.
Discussion.
We have rejected it.
You have rejected the OTS offer, then 13.8 doesn't apply.
Not yet, my lord. They have verbally rejected,
Ah,
not in writing, my lord.
We can't prevent them from rejecting your offer.
No, it's within the domain, my
You
lord.
have an option before the sale notice.
Hmm.
You see, it has been limited. Previously, it was till the sale was
Still,
effected.
correct, my lord, before the amendment.
Take instructions and then press, otherwise we'll discuss it in no time.
Monday. Can it be on Monday, my lord?
Yes, it can be on Monday,
Yes.
by the amount due with all cost, charges, expenses.
Correct. That is correct. my lord. Till then, my lord, they will. Till
And
Monday.
you have quoted in your petition, Celir LLP versus
Yes.
Bafna Motors.
No, that is
Yes.
prior to amendment, my lord. Prior to amendment. That is prior to amendment.
Right?
That is prior to amendment.
Take a call. Otherwise, if you can't do that, go there, then perhaps they're right in rejecting it.
Yes. My lord,
They
at
must
least,
come out with a sale notice. We don't say so. I mean, it's like clawing back the money. So it's very.
so until
But some
Monday,
protection you've got, let
until
us-
the next date, until Monday, my lord, they will not proceed further. We'll take
That we cannot say that unless we have it. I mean, there is some binding on us, no?
till today, my lord, they have not issued. So since the matter is pending, my lord.
We can
at least-
only orally tell the council.
Oh,
Wait till Monday.
no, I will wait,
Heavens are not going to fall.
Yes.
Monday. And it's going to count your. It can only go back to. On that. It can only come on 15th. Till 15th, don't issue a sale note. I don't think you'll be able to do that. Otherwise, you'd have offered it to the respondents.
My lord, my lord, the
Contest it, go before DRAT, and then whichever bombing.
But if they had put it on black and white, the rejection for settlement of OTS, that may be furnished to us, man. Whatever they have.
Yes, we have, but. You have heard Mr. S. Talukdar, SK Talukdar and Mr. S. Datta for the parties. There is an application seeking a direction to the respondent to accept the proposal of the petitioner for a one-time settlement. It appears that since loan amount obtained by the petitioner from respondents was not returned, it was declared an NPA, and notice was issued to the petitioner. Demand notice was issued to the petitioner under section 13(2) of the Surface Act 2002. Did you file objection petitions also? You filed objections. Stop. The objection raised by the petitioner under section 13(3)(a) was also dismissed. The petitioner went before the DRT.
A symbolic position was also taken.
Thereafter, symbolic possession of the property, symbolic possession of the placed property was taken. The petitioner went before DRT, but to no avail. It has been submitted on behalf of the petitioner that till date, no sale notice or notice for auction sale has been issued by the respondent, and the petitioner would like to redeem the pledge and secure his assets and secure his assets. Which is within his statutory right of redemption of secured asset under section 13(8) of the Surface Act 2002. However, it appears from the pleadings that a proposal was put up by the, where was that? Proposal was put up by the petitioner to the respondents for a one-time settlement, to which perhaps the respondents are not agreeable. The petitioner has a right petitioner has a right of redemption till the issuance of sale notice or notice for auction sale, but only if he pays the costs, the dues, along with all costs, charges, and expenses. Mr. Talukdar learned counsel to the petitioner seek some time to take instructions to the matter before finally addressing this court. Mr. Datta submits that in all its probability, no sale notice shall be issued till 15th of September. That's the maximum, Mr. Talukdar.
Correct. Obliged.
With no binding, direction to the respondent.
Correct. Deeply obliged.
Daily list for hearing, item 6.
We'll back after 2 minutes. We'll come back after 2 minutes.
My lord, we're just seeking an accommodation for this matter, my lord.
So tell us only after we come back.
My lord.
There's some problem.
Item number 6 for hearing.
Yes,
My
you were
lord,
saying something.
we are seeking some accommodation today, my lord. This matter, my lord, Additional Advocate General B. Gogoi will appear, my lord.
Okay.
So, my lord, I have taken from the other side, even consent, my lord.
As paid for on behalf of the respondent and agreed to by the counsel for the petitioner. Let this matter be listed. It goes in October then. November.
23rd or 24th.
Oh, this is a writ petition filed in the year 2015.
Yes, my lord.
And for
No.
10 years, what has happened?
What has happened, my lord? In between, my lord, a lot of departments have been implemented in 2023-24.
No, but
So-
the issue would remain the same, no?
Yes, yes. Issue is, yes, my lord. They have challenged, my lord,
The virus of the
virus of an act, my lord.
Prabha from Autonomous Council.
Act, my lord.
It exists.
It
The
exists.
council exists.
Yes.
Yes, ma'am. There is.
All right, we will hear it, then we'll hear it in November. And please don't take adjournment on that.
No, my lord, no.
Okay,
November.
okay. We'll hear it.
Yes, my lord. This is a very important issue, my lord.
All right, no, what is the importance? If it has been running on the list, it is live for 10 years.
Right.
Then I don't think it's very important. Anyway, we'll conclude it. November.
4th of November, 4/11. Item 8.
Lord, the documents convenience compilation couldn't be put on record because my learned colleague in Guwahati is unwell. So now today it'll be put on record. Lord, can your lordship have it on the 8th if possible? I'd be grateful.
8th of September.
8th of September, my lord.
Ms. Geeta, it will not be possible because the bench would not be there on that day.
Oh, all right, my lord. Sometime
It has to go from
24th. Is
I-
24th convenient?
24th. 24th.
Grateful.
You are appearing for
24th of September.
24th.
September, yes. Any difficulty, Mr. Parekh?
Well, it will be just before the vacation.
Doesn't matter.
Usually, my lord, the weeks before
The
vacation,
judges
my
will be available. Talk about yourself.
lord. Normally, my lord, the week before
When do you want
vacation.
it?
It'll be also easy for us to come. So if my friend can accommodate. The documents didn't come on record, so I just cancelled my tickets last time.
They hear in the last week before the court closes for Dasara. There are only admission matters, no hearing. So we keep it after the reopening. Would it be okay?
My lord, when is that, my lord? I'm traveling for a Law Asia conference in October. So if 24th is not convenient, then my lord, I'll just see what is possible. My lord, when is it reopening? I'm the one who's at fault.
Have
So if
have it any time between 13th to 17th of October.
my lord, I'm just coming back then. So after a long Law Asia conference, can it be the next week? Can it be the week after that if it's working?
No, it's not working. The court closes from 26th.
Mm.
Have it sometimes on maybe on 23rd of November or 23rd of October.
My lord, I think that's fine. 23rd is great.
Again, a
20.
prayer for adjournment has been made on behalf of the petitioner, no, on behalf of the
My
petitioner.
lord, just that the documents have not come on record, if your
That's
lordship.
all. A prayer for adjournment has been made on behalf of the petitioners for the reason of the compilation of records not having been filed to them. Compilation of submissions, compilations of records not having been filed to them. With the consent of the parties, the matter is adjourned to 20, which date we have said?
23rd October.
23rd of October.
Grateful, my lord.
Problem.
Item number 9.
Yes, Mr. Das.
May it please your lordship, my lord.
My lord, a challenge herein is the order passed by the learned Central Administrative Tribunal. Lord, before I take your lordship through the facts of the case, I'll
Yes.
I would like to show the manner in which the learned tribunal had decided the matter, my lord. The manner in which. Lordship will kindly
No,
come.
that is commenting on the order only, no?
That's
What
true.
is manner?
My lord, what happened? I'll just say, my lord. One order was passed by learned tribunal on merits in the absence of the petitioner's counsel. And OA was dismissed, only recording the submission of the respondents. My lord, that order was tried to be reviewed by the present petitioners. Review was filed. Review was rejected. Thereafter, that order was challenged before this honorable court.
What was that order? What happened?
My lord, why I'm saying so
See,
the
we are not, at the moment when we are hearing this against the order of the CAT, we let us confine ourselves to the merits. In the last, if you have any other brownie points to make with respect to the manner in which it was decided.
my lord,
we can take it.
why I started with this, my lord. I'll take your lordship with the merit. Why I started with this, my lord. The learned tribunal, by the impugn order, had decided the issue on the basis of an order of the tribunal, which was already set aside by this court.
Let's see.
That's why.
This
I'll
is,
just
this
fine,
is a
my lord.
vague statement when you have, once I
That's
read
why
it,
I wanted to take your lordships to the impugn order.
impugn order is the first thing that we see, no?
Yes, my lord. That's why it will, my lord, serve both the purpose. It will give your lordship an insight of the matter, as well as, my lord, the manner how the learned tribunal
You
decided.
get it at which page?
The order starts from page number
442.
4, relevant portion 487.
No. Start at 442.
Yes.
That, let us see that order from the first. 442.
Yes, 442 it starts. Relevant portion, if you lordship will find, page 487.
Yes.
This is the third round of litigation. So and so have sought for following relief to quash and set aside the impugn office memorandum dated 4/9 December 2014. To direct the respondents to introduce pension scheme in the Brahmaputra board strictly in terms of the OM dated so and so issued by the government of Assam Ministry of Personal Public Grievance and Pension with all consequential benefit. This tribunal-wide order dated 28/4/2016 had dismissed the OA. The applicants assailed the said order before the Honorable Guwahati High Court by way of WBC 1359/17 on the ground that the OA was dismissed on merit without hearing the learned counsel for the applicant. The Honorable Guwahati High Court wide order dated so and so held that this tribunal ought not to have dismissed the OA on merits without hearing the counsel for the applicants and accordingly set aside the order dated so and so. The matter was remitted back to this tribunal for consideration in accordance with law. This is how the matter has came up for consideration before this tribunal again, and the matter was heard on so and so. We have heard extensively, Sri so and so. Now, para 3, the senior counsel of the applicant have taken us to the grounds raised in the OA and submitted that Brahmaputra board is a statutory body established by an act of parliament. Learned senior counsel forcefully submitted that Brahmaputra board follows the government of India rules, regulations, mutatis mutandis and pay scales, and its recruitment rules have been framed in consultation with the central government and the duly notified in the official gazette. Accordingly, according to the learned senior counsel, Brahmaputra board functions like a central government subordinate office. Learned senior counsel further submitted that unlike any other autonomous body, no MOU is signed stroke executed by the Brahmaputra board with the central government. The learned counsel for the respondents, on the other hand, submitted that on the same course of action, the applicants have approached this tribunal time and again by taking note of OM dated 1587, which is not applicable in the case of employees of Brahmaputra board. According to the learned counsel, the claim of the applicants could not be acceded to based on policy decision and therefore prayed that this tribunal may not interfere with the matter. We have also gone through the pleadings and materials placed on record and orders of this tribunal dated 28/4/2016 and the judgment dated so and so of the Honorable High Court. The specific contention put forth by the applicants before the Honorable Guwahati High Court
that this tribunal had dismissed the OA on merits without hearing their counsel. On perusal of the order of this tribunal dated so and so, it is apparent that although learned counsel for the applicants was not present on that particular day, this tribunal had considered their submission.
This is a justification for passing an order in the absence. Now, the issue, where are the issues?
Yes.
Are the issues dealt there?
My lord, what the learned tribunal did, the learned tribunal quoted,
That we have followed. So this I say as a justification for
this is
dismissing
a
the petition.
justification, while deciding, learned tribunal quoted the paragraphs of the
We
previous.
have followed
Yes,
that.
yes, para 6. This tribunal in its earlier order dated 28/4/2016 considered every aspect of the matter and passed a detailed order. Paragraph 13 to 20 are reproduced as under.
This is the entire thing is
Exactly, my lord.
quotation.
Complete non-application of mine, with all due respect. Complete non.
So therefore, the order dated 28/4/2016 has been reproduced after hearing. Now, that's one aspect of the
And-
matter. So let's see the paragraphs here. Why do we talk upon it?
Yes.
Let's start at page 490 and page 49. Internal page 490, paragraph 4.
Yes, ma'am.
Quoted paragraph 4.
Yes, ma'am.
Yes.
The brief facts narrated by the applicants are that all the applicants are working in Brahmaputra board on various posts under various offices of the board. The Brahmaputra board is a statutory setup by an act of parliament in the name and style Brahmaputra Act 1980 under the erstwhile Ministry of Irrigation, now renamed as Ministry of Water Resource, River Development and Ganga Rejuvenation, Government of India. The applicants further submitted that the board adopted the Contributory Provident Fund CPF in short scheme for its staff in lieu of pension scheme against the will of the employees of the board. However, option was kept open to switch over to a pension scheme, treating the introduction of the CPF scheme as a stopgap arrangement. The matter regarding the adoption of the pension rule and contributory provident fund was discussed in the first meeting of the board held on 2nd and 3rd June 1982 at Guwahati, and the resolution adopted by the meeting in this regard to the agenda item number 14 is as follows. The provision of CPF for the employees as presented in the agenda item was approved in principle to start with, for which details may be worked out and presented to the board. Thereafter, in the second meeting of the board held on so-and-so, the minutes of the first meeting was confirmed as the first agenda item, and action taken in their implementation was reviewed as the second agenda item. According to the applicants in the agenda item number 14 in the first meeting of the board, it was resolved that the matter pertaining to adoption of pension scheme will be decided after joining of the financial advisor. However, the board, infringing its promise, sat over the matter of implementation of pension scheme in the board. Applicant further stated in para 4.2 of the OA that the 4th Central Pay Commission by the Government of India made recommendation that all CPF beneficiaries who were on service as on 186 were deemed to have been switched over to the pension scheme unless they opt otherwise. Accordingly, the Government of India, Department of Pension and Pensioners Welfare of the Ministry of Personal Public Grievance and Pension issued office memorandum dated 1/5/1987 stating that all CPF beneficiaries who were in service as on so-and-so would be deemed to have come over to the pension scheme. It was further stated that a total of 895 employees out of 950 employees at the relevant point of time of the board exercised their option in favor of the pension scheme, and only 5 employees opted to remain in the CPF scheme, meaning thereby almost all the employees of the board favored for implementation of the pension scheme in the board as per the OM dated so-and-so. The applicants represented the matter before the authority also, while there are several representations dated so-and-so, so-and-so, so-and-so. As no positive response came from the respondents, the Brahmaputra Board Employees Union made a representation dated so-and-so to the Secretary to the Government of Assam, Ministry of Water Resources, requesting to look into the grievance pertaining to non-introduction of pension scheme in the board. Thereafter, again, the Engineers Association of the Brahmaputra Board submitted a representation dated so-and-so, but to no avail. Being aggrieved, the applicants approached this tribunal by filing OA number so-and-so, praying for a direction to introduce a pension scheme in the Brahmaputra Board. This tribunal, by order dated so-and-so, disposed of the said OA, directing the respondents to adjudicate the representation dated so-and-so submitted by the applicant. In compliance of the order passed by this tribunal, the respondents' authority passed the speaking order dated so-and-so, negating the prayer of the applicants towards implementation of the pension scheme in the Brahmaputra Board.
Again, the applicants approached this tribunal by filing OA number so and so. This tribunal, white order dated so and so, dispose of the said OA, directing the respondent one to consult the issue of pensionary benefit in the light of the OM dated so and so. Against the order of the tribunal, applicants approached before this Honorable Guwahati High Court by filing WPC 1922/2014, challenging the legality and validity of the order dated so and so passed by the Honorable Tribunal in OA number so and so. This was by the Union of India. Honorable High Court, after hearing the parties, dismissed the said writ petition, white order dated so and so. The applicants categorically stated that after issuance of the OM dated so and so, the board had taken option from the employees pertaining to adoption of pension scheme, and vast majority of employees had exercised their option to switch over to the pension scheme, and in terms of the said office memorandum, the applicants are entitled to switch over to the pension scheme, and as the CCS pension rule 1972 are applicable to their counterparts in the central government who had joined along with them, the applicants are also entitled to be covered by the said rules. Hence, on this code alone, the present original application deserves to be allowed. The applicants further stated that the respondents committed serious illegality by negating introduction of the pension scheme in the board on the ground that Brahmatra board is an autonomous body and its employees are not at par with central government employees. The Brahmatra board is not an autonomous body, rather it's a statutory body set up under an act of parliament in the name and style Brahmatra Board Act 1980. The Brahmatra board does not enjoy any autonomous, likewise, other autonomous bodies because board is in deep and pervasive control of the central government. The fund for achieving the goal and objective of the board comes from central government. The chairman, vice chairman, and general manager are appointed by the Ministry of Water Resources. According to the applicants, the respondents totally overlook the mandate of the circular dated so and so. The circular is clear enough regarding its applicability. The circular is squarely applicable in respect of the board, and the decision in contrary to the circular is bad in law and liable to be interfered with by the tribunal. This tribunal in its earlier order dated 28/4/2016 considered every aspect of the matter and passed a detailed order. Paragraph 13 to 20 are as under. Para 13, my lord. The very issue involved in the present petition is for introduction of pension scheme in the Brahmatra board on the basis of OM dated so and so, issued by the Government of India, Ministry of Personnel, Public Grievance and Pensioners Welfare. Now I am in hand with the OM dated so and so on the subject of change over of the central government employees from contributory provident fund scheme to pension scheme. Implementation of the recommendations of the 4th Central Pay Commission, clause 6.1 of the said OM reads as under, my lord. This order shall apply to civilian central government employees who are subscribing to the contributory provident fund under the Contributory Provident Fund Rules 1962. In the case of other contributory provident funds such as Special Relay Provident Fund or Indian Ordnance Factory Workers Provident Fund or Indian Naval Dockyard Workers Provident Fund, etc., the necessary order will be issued by the respective administrative authority. It is noted that option was exercised by the employees of the Brahmatra board for switchover from CPF to GPF. As that has not been responded, the applicants approached this tribunal, white OA dated so and so, where this tribunal, white order dated so and so, dispose of the said way with a direction to the respondent authority to adjudicate the representation dated so and so made by the applicant in a period of 2 months from the date of receipt of the order. Thereafter, in compliance of the said order, the respondent authority passed the speaking order dated so and so, rejecting the prayer of the applicants with the following grounds, amongst other, mainly, the OA so and so filed in the Honorable CAT Principal Bench, New Delhi, was although passed in favor of the applicants for introduction of the pension scheme, it was challenged before the Honorable High Court, wherein Honorable High Court had passed the order of Honorable Principal Bench passed in OA so and so. The employees of the Brahmatra board can contribute to the pension scheme introduced by some public sector undertaking like Life Insurance Corporation of India for the purpose of pension, which should be in addition to the existing CPF scheme without any contribution from the central government. Further, the Government of India has taken the following ground. In view of above introduction of pension scheme, which is already ceases to exist from 1/1/2004, as per the policy decision of the Government of India, cannot be introduced in the Brahmatra board afresh, which may otherwise create a huge financial burden for the Government of India. Being aggrieved, the applicants again approached this tribunal by filing OA number so and so, where this tribunal, white order dated so and so, disposed of the said OA and directed the respondent authority, more particularly Ministry of Water Resources, to consult the issue of pensionary benefit in the light of the OM dated so-and-so for the employees of the Brahmotro board with the Department of Pension and Pensioners Welfare and thereafter take an appropriate decision in this regard within a period of 4 months from the date of receipt of this order. Against the said order of the tribunal, applicants approached before the Honorable High Court by filing WBC so-and-so, wherein the Honorable High Court, after hearing the parties' right, order dated 7/4/14, dismissed the said writ petition. Thereafter, the respondent authority right impugn OM dated 4/9/12/24 rejected the prayer made by the applicants on the grounds, amongst other, that the Department and Pension and Pensioners Welfare had issued OM dated 1/5/87, whereby all the central government employees who are in service deemed to come in GPF scheme. Further held that the recommendation of the Central Pay Commission are not suo motu applicable to the employees of the autonomous body unless extended by the government. Department of Pension and Public Welfare has opined that this OM is not applicable to the board employees. The government has been consistent in not extending the benefit of pension scheme to the employees of autonomous bodies who are covered under CPF scheme. From a bare reading of this, it emerges the object and interpretation of very OM dated so-and-so issued by the Departments and Pension and Pensioners Welfare, on which basis the Brahmotro board employees exercise their option for switchover from CPF to GPF, in fact, is for the central government employees, not for the autonomous organization. From the series of litigations as well as from the pleadings, undisputedly, the employees of the Brahmotro board are not the central government employees. They are the employees of the board, which is an autonomous body, and as such, the benefit of the OM dated so-and-so shall not be extended at large without having any right to claim. Further, it is noted that the Government of India have introduced new pension scheme based on the defined contribution for new entrants requited in central government service on or after 1/1/2004. In other words, the present policy of the government is not to extend the benefit of the defined benefit pension scheme to those who are already not covered under the said scheme. The proposal for various autonomous bodies for a shift from CPF to GPF come pension scheme or for creation of pension fund in respect of employees who joined before 1/1/2004 were considered by the government, Ministry of Finance, and it was decided that such autonomous organization may be permitted to a defined contribution pension scheme, i.e.
We have followed, yes.
Now, after discussing all this, the conclusion.
The quotation from the judgment of Supreme Court was neither here nor there. That was not the issue.
Exactly. Para 20 and 21. That was the conclusion. This, my lord.
This was never questioned. The
Yes.
OM dated 1/5/1987 by the Ministry of Personnel does not reflect any unreasonableness so far as the present case is concerned.
Exactly, my lord.
That means nothing. The rejection of change from CPF to government as per policy does not reflect and not against the statute. The only thing was whether Brahmputra board, even though comes under the state within the definition of Article 12, would be taken to be a state to such an extent that the employees of board would be treated as employees of the central government. There you have the case law straight that notwithstanding a body coming under Article 12 for pension and other benefits, other aspects have to be seen. You have been receiving salary from grants in aid, not from the Consolidated Fund of India. Therefore, that pension scheme will not be applicable to you. 1/5/1987, that circular, I mean, this is a tentative observation. You have to argue.
Fine. Correct.
So this is it.
Before that, my
All
lord,
this
may I-
in this manner and everything goes no.
because before that, para 21 of this page 496, the learned tribunal decided that thus from the above discussion as well as following ratio laid down by the so-and-so apex court as mentioned, so the OM dated so-and-so shall not be interfered with, finding no merit, OA is dismissed. My lord, we never challenge the OM.
Anyway, that's a faulty way of drafting an order.
My lord,
Nonetheless,
we-
your issue
we-
is what has been
Yes,
decided.
my
That
issue.
you are not entitled for pension. You
Yes.
only get CPF.
My issue revolves around the OM dated 1/5/1987.
So that is, even if it is accepted to be correct on record, applicable, it is not applicable to you. That's the contention.
That's the contention of the respondents.
That is because of the law, because that distinction can very easily be
Milord-
made, Mr. Das. Mr. Das.
I understand, my lord. If I take your lordships to the OM
Mr.
itself,
Chaudhary, get hold of those decisions where even if a body is taken to be a state, for courts to issue writs, for it to be amenable to writ jurisdiction, for pensionary benefits, for other things, it may not be treated, their employees may not be treated as government employees. There are judgments, line of judgments. You have to find out, you have to do some research work and just don't wait for the court.
Milord, the answer to this question lies in the OM itself, Milord. If your lordships kindly take the
OM is all right. Mr. Das, if you make efforts on that which is not necessary, then perhaps your.
Milord, may I just explain the situation? Prior to coming of this OM,
Let us see the OM.
yes, my lord, that's what. Page 434, my lord.
Hmm. 434.
Yes. My lord, concerning this OM, there is a Supreme Court judgment of 2022. My lord, I'll not take your lordships to that, but this question.
Read the subject.
Yes. Change over of the central government employees from.
Central government employee, argue on that. Are you a central government employee? Forget about all
No,
this.
no, my lord, I'm not a central government
Then-
employee, but this OM itself says that it can be extended to other autonomous.
Has it been extended?
Exactly.
Has it been extended?
That's why, my lord, option was sought. It was extended to us. My lord, there is a agenda
You
item.
exercised your option, but it is under the powers of the state not to grant that. And otherwise, the policy of pension has been done away with since 2004. You may be an appointee.
That's a
of-
different thing altogether. New pension scheme came 1/1/2004. That's a different thing altogether. But when we are seeking benefit of this OM, and this OM was.
Read that part of the OM which says that it can be extended to other
Yes,
branches.
yes, my lord. Lordship will kindly come to page 435. This order apply to all civilian employees who are
Where are
subscribed.
you reading?
Page 435, para 6.1, my lord. These orders apply to all civilian central government employees who are subscribing to the Central Contributory Provident Fund under Contributory Provident Fund Rules 1962. In case of other contributory provident funds, such as Special Railway Provident Fund or Indian Ordnance Factory
Do you
workers
come in this
provide
category?
fine, etc.
You don't come in this category. Brahmaputra
No, no.
Board, it's a body under a statute. Or body by a, no, it is a body under a statute,
True.
not by a statute. Doesn't make a difference. But then you don't come.
I am not on that
We are
point
on
that
that.
I am a central
Mr.
government.
Das, we are on that.
I'm sorry.
You have to satisfy us that as an employee of Brahmaputra Board, you have the status of a central government employee. That would be the end of the matter.
My lord, this OM was made applicable to University of Delhi. What I'm saying so, there are there are issues which went up to Honorable Supreme Court because this OM, if an autonomous body or a board wants to implement this.
Nobody in Delhi University is getting a pension.
My lord, I'll place the judgment. Before that, I'll
Nobody's
just place.
getting a pension, that much I can tell you.
My lord, before placing the judgment, I'll just place the facts.
It's only in
Look,
few
what-
of the state universities, maybe in Bihar, maybe in Uttar Pradesh, that the services are pensionable.
No, what I am trying to, my lord, persuade your lordships is that
Unless,
this OM,
unless you make us cross this hurdle, we will not be hearing the other arguments because we
my lord,
must know.
I am trying to cross this hurdle only.
Okay.
My lord, it was never my case before the learned tribunal that I am a central government employee. Give this benefit to me.
My
case is
based on the fact that this OM
has
this
been.
OM could be extended. It was extended to Brahmaputra Board.
My lord, yes, this OM was adopted by the Brahmaputra Board, and by virtue of that adoption, options were given to us to come over to the EPF and pension scheme.
In those paragraphs which has been quoted by the CAD, by the tribunal, those facts have been stated. See, initially it was CPF. It was a temporary measure. Decision was kept pending till the joining of the financial advisor. Financial advisor joined. All this has been noted down. But where the fulcrum would lie somewhere when it would be decided that you are a central government employee, number one, or whether it has been extended to you.
Exactly.
This extension also is very limited. It is with respect to government employees. Look at this. Special orders would be passed in favor of Indian Naval Dockyard for railways,
Etc.
etc.
The
All
necessary
these-
all,
All the employees, Mr. Das.
I'm sorry.
Try and understand.
I'm sorry.
All these employees in all these organizations, they may be autonomous, whatever, but they are actually the central government civilian employees. You don't fall in that category, unfortunately. Therefore, even if otherwise it is treated to be a state, we can issue orders against Brahmaputra board because it is creates a statutory body with overwhelming presence of the state. Agreed. For pensionary benefits, for other matters, you are not treated as a government servant. Would the central civil service, what is that?
CCS rules.
CCS
Yes.
rules, will it apply to you?
Yes.
Unless you accept it.
No, no.
That is for the board to accept.
Milord, the Brahmaputra board has made the CCS rule
Applicable.
applicable
It is
to
not
us.
applicable for you. Automatic. There's no applicability
Milord,
automatic.
I'm not saying it is automatic.
No, tell us where it has been extended now.
Milord, I'll just,
Unnecessary-
Milord, one more paragraph, Milord, of this particular OM. Para 7.2. In the next page. 436. Administrative ministries administering any of the contributory provident fund rules other than contributory provident fund rule 1962 are also advised to issue similar order in respect of CPF beneficiaries covered by those rules in consultation with the Department of Pension and Pensioner Welfare. I'll just take, Milord. Now, by this OM, what the central government had introduced, I'll just take your lordships to para 3.
Just a minute. Let us see the stand of Jal Shakti Department. Let us see the stand of Jal Shakti Department. If you follow this, then let us see that.
Milord,
Who appears for Jal Shakti? You are appearing, Mr. Chaudhary. What have you stated?
If your lordship will come to my affidavit that starts from page 499. Insofar as the
499 is the second volume, no? Is that it? We don't find 499. 490.
499,
Very good.
91
oh, is it?
498.
एक
इसके बाद है अगर they have 499. Yes, yes.
Yes.
There, after this.
Now,
Yes, yes.
internal lordship page 6, running page, it will be 504.
Green paper.
Affidavit बने। हाँ, अपन affidavit। 6.
We have that. Yes. Maybe we have I think all papers appear to be honestly there. Earlier. Otherwise, the docketing is very difficult to handle. Yes, internal is 6.
Lordship, if your lordship will come to internal page 6,
Yes.
the second para, it starts with it is to be mentioned. That the employees of the Brahmaputra board who are subscribing to the CPF scheme are governed by the National Water Development Agency Contributory Provident Fund Rules 1982 and not the Contributory Provident Fund Rules 1962, because that notification which my friend is relying upon, that is the CPF rules 1962, that refers to the CPF rules 1962. In any view of the matter, lordship, the next paragraph.
So the 1587 OM relates to CPF rules, CPF fund rules of 1962.
Yes.
They are being governed by the National Water Development Agency
Yes.
Contributing Fund Rules 1982.
So in any view of the matter, we have put it up before the appropriate department, the next paragraph, lordship. In that view of the matter, the employees of the Brahmaputra board are covered under the third situation, and we say under clause 7.2, which my friend was just reading, of the office memorandum dated 1587, and not under the other two situations, and we say under 6.1. Thus, in view of the advice contained in 7.2 of the memorandum, the Ministry of Water Resources ideally should have consulted the Department of Pension and Pensioners Welfare for issuance of similar order as office memorandum dated 1587 of the employees of Brahmaputra board. However, Ministry of Water Resources, Government of India has consulted the matter with various departments like the Department of Expenditure, Ministry of Finance and DOP and PW in respect of the representation from S.K. Burwai is one of the employees forwarded by one member of parliament regarding introduction of the pension scheme in the Brahmaputra board. Now, if I may take your lordship to the office memorandum dated 3/7/2000.
No, let's see this. You have reduced it into
Yes,
points.
yes,
At
that
page
is there.
internal page 7. Those are the answers, right?
Lordship.
Read.
One, the Brahmaputra board is an autonomous body and therefore the provisions of Department of Pension and Pensioners Welfare Office Memorandum dated 1/5/87 are not directly applicable to the employees of the Brahmaputra board. However, in their representation dated 3/5/13, they have sought conversion from CPF to pension scheme on the basis of our OM dated 1/5/87. Therefore, the provision regarding applicability of the provisions of this OM is given below. Consequent upon the recommendations of the Fourth Pay Commission, Department of Pension and Pensioners Welfare issued OM dated 1/5/87 gave a final option to the central government CPF employees to come over to the pension scheme. As per the OM, those who wanted to remain in the CPF scheme had to exercise an option. And the last date of exercising such option was 30/9/1987. The provision of this OM was applicable only for central government employees subscribing to CPF under the CPF rules, India 1962. The last date for exercising the option was not extended further. During 1980s and early 1990s, the CPF scheme was more attractive than the pension scheme. Therefore, some central government employees had specifically opted to remain in CPF scheme. These employees continued in CPF scheme. However, in the latter part of 1990s and 2000, these employees requested for one more option to switch over to pension scheme. This is because of the fact that consequent upon the recommendations of the 5th and 6th Pay Commission report, pension scheme has become more attractive.
But then you admit that it was extendable to even this board because it is controlled by that central act.
Lordship will come.
That you say it was not extended because the Department, Finance Ministry, Expenditure Ministry, they said no, don't convert. So to that extent, Mr. Das is correct that it was extendable to you, even though why did you admit this? I don't think there was any reason to admit this.
No, Lordship.
No, it was not extendable to this. No, it was the first check was central government employee.
Yes.
They are created under a statute, but they're not central government. Grants in aid, that's one big test. Salary from grants in aid, not from the consolidated fund. They are not government servant.
Lordship, that is the.
They would have all the perquisites of a government servant. It's a board, but pursuant to the rules, they'll get everything. But so for a pension, whether this OM was extendable to them is a question which you have admitted. But then you say that it was not extended.
It was not extended, Lordship. That is.
The spin-off effect. There had been a litigation. The judges of district court in state of Bihar, and many other states, they were amenable to CPF. But once they became high court judges, there was a rule which said that no, they can't have the option to switch over. Ultimately, it was decided by the Supreme Court that no, they are in a service. Every judge from whichever source he comes from, he is a judge. He will have a pension. He will have pension. But then for the period that he worked as district judge, the only consideration made by the Supreme Court was that their contribution
will be refunded and will be converted.
The government's contribution also to be refunded.
Correct.
But finally, a judgment was given that only the government. This is the spin-off effect of switchover. And from 2004, the union government has decided not to extend it to any. So how can we direct? These are financial matters. We can't possibly do anything.
Yes, I have got submission. Lordship may not be inclined to take a view, my lord. I'll just place the facts.
They are only, see, this is why we can just hear you and dictate the judgment.
Correct.
Take it home, take it to my chamber.
Correct.
And this is not our practice.
No.
We argue with the lawyers.
Yes.
So therefore, these
No, I'm absolutely fine. Your lordship is expressing, my lord, or asking questions, my lord. I'm absolutely fine. I'm bound to answer to your lordship.
So our orders, would
Entire,
otherwise our orders also would be amenable to the same criticism which
Milord, it was not a criticism, Milord. It was a ground taken in the writ petition, Milord. Lordship will kindly consider.
Say we don't find any reason. The reason given by the tribunal may not be correct. We'll have our own reasons, but prima facie we are not finding.
Milord, the only
Yes.
hurdle,
Unless you have some other very ingenious way of developing your case, tell us.
Milord, the only, Milord, after reading the brief, the only hurdle I found for myself is whether the Brahmatra board had adopted the OM, and whether the employees were asked to submit options or not.
Suppose that is given. That
Yes,
is on record. It has not been disputed.
correct.
So your a statutory body, I mean, a body created under a statute may adopt any resolution. If it has financial connotation, it has to be extended by the proper authority, which is the government. Has it been extended? No, it has not been extended. Who denies that Brahmaputra board accepted? See, for some time, for about good 4 or 5 years.
I understand. Yes,
Good 4 or 5 years, it was not made known to the Brahmaputra board management.
correct.
When the matter was known, they asked for the options. But for 5, all other agreed. And they wanted a switch over. It could not have been done because it was not, you adopted it, but it was not extended to you. That is the question. No, when was it extended? Tell us. It was extendable to you because our reading of the OM is very clear that it was not even extendable to you. But they, in the government, the department, it says it was extendable, but we took a call, we did not extend for these reasons. Our view is that it was not even extendable to you from the beginning.
True.
No,
But-
not true. That's
No, no.
against you.
That, no, that against me, fine, my lord. But that is your lordship's view, is correct. But the second, it was extended to us. There is no,
Adoption is not extension. You say that, the advocates body,
your lordship is saying,
body has always been, fighting for some kind of stipend to advocates.
Correct.
You adopt the resolution. Would you claim a stipend from the government? Your
lordship is saying you have adopted, your lordship is,
Suppose we adopt some resolution for extension of age. Do we claim? Not leave the office after 60.
ultimately, your lordship is saying that there has to be a decision by the government that we are giving you this. That is extending.
And
Whether
no
that is,
let me tell you, Mr. Das, despite all this litigation, no authority. Not even, you go to Supreme Court, not even in 142 it will be given. These are very difficult matters to.
Milord, this question came up for consideration, Milord, before the Honorable Apex Court, this OM itself. Milord, what happened in that matter, Milord? Some of the employees,
Let us not argue, let us not hear the argument, let you not argue vaguely that it was considered in. Can you show any judgment of any authority? Supreme Court, of course, it will be binding on us, any High Court, Supreme Court judgment, which says that no, this OM was to be extended to all bodies, all instrumentalities of the state. You show me that order, we will change our.
fine, Milord. I'll try to.
Given you a platform to take it, gentlemen. We are done with the matter now. We are done with the matter now.
Can it be in the next week?
How many times would you ask us to read?
Sorry, Milord.
See, the
I'll
difficulty
also-
with difficulty with this. I mean, I'm talking about myself, not about my brother. See, memory is short, no? Now
No,
now we have
no.
read all that.
Milord, this is not believable.
This
This is not believable, my lord.
again, everything will be washed off from the memory.
No,
Here we have read.
Milord, even if the point goes against me, Milord, I'll apprise your lordships with the facts, Milord. That this is your lordship's tentative, Milord, reading of the facts, I'll apprise.
At 2 o'clock?
Yes, ma'am.
At 2 o'clock,
Yes,
we'll conclude.
Milord, since lordships paused the query, Milord, may I just explore that possibility? Because
Anyway, we will pass some order at 2
my lord,
and then adjourn the matter for another date, only the last date.
fine, my lord, no issues. I'll just try to satisfy myself and try to persuade your lordships, Milord.
All right. Which page was the order passed by the cat, by the tribunal?
Page, my lords.
11 portion starts from 487.
My lord, it starts from page 442. And relevant portion starts from
487.
yes, my lord, lordship is correct. 487.
And when is it? It's 434. 434. The issue raised in the present petition is whether the office memorandum dated 1/5/1987 issued by the Ministry of Personnel, Public Grievance and Pensions, Department of Pension and Pensioners Welfare, with respect to changeover of the central government employees from contributory provident fund scheme to pension scheme in connection with the implementation of the recommendations of Fourth Central Pay Commission. Is extendable to the employees of the Brahmaputra board from a statutory body established by an act of parliament. The OM is in the nature of direction to the state, that's to the states, that the central government employees who are governed by the CPF scheme and who have given their options in the past to switch over to pension scheme should be allowed, subject to the condition that the employees must be CPF beneficiaries on January 1st, 1986. Unless the employees opt out to continue under the CPF scheme. The OM also, the OM of 1987, or the OM dated 1/5/1987 further stipulates that administrative ministries administering any of the contributory provident fund rules other than the contributory provident fund rules bracket India 1962 to also issue similar orders in respect of CPF beneficiaries covered by those rules in consultation with the Department of Pension and Pensioners Welfare. Based on this OM, the petitioners approached the tribunal, approached the Central Administrative Tribunal for a direction to the respondents to introduce pension scheme in the Brahmaputra board strictly in terms of OM dated 1/5/1987. The tribunal had, by the detailed order dated 28/4/2016, dismissed the OA, but without hearing the petitioners. The order passed by the tribunal was thus challenged, was then challenged before the Guwahati High Court in WPC number 1359 of 2017. When this court, by the order dated 21/12/2018, set aside the order of the tribunal and remanded the matter to the tribunal for consideration in accordance with law. The tribunal thereafter again passed an order dismissing the claim of the petitioners that they be extended the benefits under the OM of 1987. The Brahmaputra board, the contention of the petitioners is that Brahmaputra board is a statutory body with overwhelming presence of the central government. And therefore, the employees of the board are central government employees. Central government employees. It was brought to the notice of the tribunal it was brought to the notice of the tribunal that the board had earlier adopted the CPF scheme for the employees, which was against the will of the employees of the board. However, an option was kept open for the employees to switch over to a pension scheme holding that the CPF scheme was only a stopgap arrangement for the employees of the board. Later, the board resolved that the provisions of CPF for the employees Later, the board resolved that it shall adopt the pension scheme pension scheme in view of the OM dated 1/5/1987. 1987. A total of 895 employees out of 950 employees of the board had exercised their option in favor of the pension scheme. However, the pension scheme was never extended to the employees of the Brahmaputra board, for which the employees had sought a direction from the tribunal. On a reading of the OM of 1987, especially clause 6.1 of the OM, the tribunal was of the view that the benefits under the OM of 1987 was extendable to all civilian central government employees subscribing to the CPF under the CPF rules of India 1962. As also in case of other contributory provident funds, such as Special Railway Provident Fund or Indian Ordnance Factory Workers Provident Fund or Indian Naval Dockyard Workers Provident Fund, etc., for which necessary orders was to be issued by the respective administrative authorities. Since Brahmaputra board, though an instrumentality of the state and came within the purview of the definition of state under Article 12 of the Constitution of India, but the employees who were being paid through grants in aid and not through the consolidated fund could not be treated, were not central governments, were not central government employees, were not central government employees. Recommendation of Central Pay Commission are not automatically extendable to employees of autonomous bodies unless extendable by the government. The Department of Pension and Pensioners Welfare had opined that the benefit of the pension scheme was not extendable to the employees of the Brahmaputra board who are covered under the CPF scheme. The main contention of the appellants of the petitioners herein also is that since the board has been set up by an act of parliament, namely Brahmaputra Act of 1980, bracket Act 46 of 1980, under the erstwhile Ministry of Irrigation, and now Ministry of Water Resources, River Development and Ganga Rejuvenation, Government of India, comma, it is a state within the meaning of Article 12 of the Constitution of India, and perforce the employees would be the central government employees. would be the central government employee. The tribunal rejected the claim of the petitioners / applicants basing its decision on a communication dated 23/8/2019 issued by the Ministry of Jal Shakti, Department of Water Resources, RD and GR, which clarified that since the salary and other components of the employees of the Brahmaputra board are paid from grants in aid received from central government and not from the Consolidated Fund of India, the employees of the board would not be termed as central government employees. The financial instruction, all financial instructions would not be equally applicable to the employees of the board till separate directions are issued in that regard. In that regard. Apart from that, the tribunal held that the pension scheme had already ceased to exist from 1/1/2004 as per the policy decision of Government of India, which could not have been interfered with. Mr. H.K. Das, learned advocate for the petitioner, submitted that the grounds on which that claim was rejected is incorrect. The CPF scheme for the employees of the board was only a stopgap arrangement. And later the board by its resolution adopted the pension scheme and awaited the approval of the central government, which was never forthcoming. Countervailing arguments have been advanced by Mr. R.K.D. Chaudhary, the learned Deputy Solicitor General, that the employees of Brahmaputra board are governed by the National Water Development Agency Contradictory Provident Fund rules of 1982 and not CPF rules of 1962. Semicolon, whereas the OM dated 1/5/1987 related to CPF scheme under the CPF rules 1962. It was also submitted that the Ministry of Water Resources, Government of India, had consulted with various departments, namely the Department of Expenditure, Ministry of Finance, and Department of Pension and Pensionary Welfare, in respect of the claim of the employees of the board regarding extension of the pension scheme to the employees of the board. But it was decided not to grant the option of switchover to pension scheme to the employees of the board. The reason for this was the difficulty in refunding the contribution of in refunding the CPF and its contribution after passage of so many years. And the switchover would have a spiraling effect in other departments. Thus, before this court, the sole contention now of Mr. Das or the petitioners is that no distinction ought to be made between the employees of the central government and the employees of the board, statutory body under a department of the central government. Under the department of the central government. Also, we are of the prima facie view that an organization or a body created by a statute or under a statute would come within the purview of the definition of Article 12 of the Constitution of India, but would not be treated as, would not ipso facto be treated as state for the purposes of, for other ancillary purposes like payment of pension, gratuity, etc., which would be governed by the specific rules governing the employees of the board. Mr. Das, learned counsel for the petitioner seeks some more time to finally conclude his argument. Mr. Chaudhary, learned Deputy Solicitor General, shall also bring on record the judgments of the Supreme Court, which makes such distinction, holding that not all bodies created by or under a statute having overwhelming presence of the state in the organization would be amenable to the schemes meant for central government employment. List this matter for further consideration. On what date?
Lord, can it be on 18 or 23, my lord?
Not in September.
Fine.
It was in October.
Maybe.
Now that's a limited issue. There are 2-3 judgments which I don't remember now.
2022, there's,
You have the copy.
I have, I can give the citation.
Citation would not.
I'll place it on the next step.
And give the list to him also.
Yes, yes, yes.
All
28 October.
28. Fine, man. I'm grateful, my lord. Much of this.
Item 12 and 13.
That's again for your satisfaction, Mr. Das.
I understand, my lord. I'm grateful. That's why, my lord.
Item 12 and 13.
May I please, Your Lordship?
Yes.
Your Lordship, this is the matter for which where we have challenged the advertisement pertaining to the transgender recruitment. So in that regard, Your Lordship has asked us to submit some compilations. In fact, we have also prepared 2-3 compilation, 2-3 orders and 2-3 notification of the Government of India we are waiting to receive from my juniors there in the Supreme Court. And once we receive the same, we will place it on record through compilation, through filing the compilation. But
let's have a composite hearing.
But prior to that, Your Lordship, if Your Lordship may just consider, if Your Lordship may just see the petition, page number 31.
Yes.
This is the Assam state policy for the transgender. And here the 7.2.4 employment, livelihood and sustenance is specifically says,
And apart from that, if we go through the newly enacted Act, Trans Act 2019, then Section 3B. If your lordship, if the court masters can give the Transgender Act 2019, your
Now,
lordship.
in the compilation, why can't you argue on the day when you have the compilation ready with you?
Yes, no issues, your lordship.
Hear you on that date.
Yes.
Take them. This public interest litigation aims to address the grievance of the petitioners against the police department for them having published an advertisement which they claim to be discriminatory for the recruitment of transgender persons as sub-inspectors and constables. The advertisement in question has put the transgenders together with male aspirants, and the criteria set for transgender applicants are identical to those for male aspirants, which in ultimate analysis negates the distinct identity and needs of transgender persons. The contention on behalf of the petitioners, / all Assam Transgender Association is that such a recruitment process is against the law with respect to the transgenders. Swati B. Barua, learned advocate, submits that the compilation of all the acts, circulars, and judgments is under the process of is under process and shall be produced for the perusal and convenience of the court on the next date. Let this matter come up for consideration. On what date would suit you?
Your lordship may fix it after vacation. Vacation will be fine.
On 30th of October.
30th of October. At the same time, one little request, if your lordship may just permit. Your lordship, there is another one PIL, which is a PIL 74, and which was required to be listed, but 2-3 months has been passed by and the matter has not been listed.
So. Let PIL 74 of 2025.
2018.
Of 2000, PIL number 74 of 2018 be also listed along with the aforementioned PILs. All right, Mr. Nath, what could be the, I mean, where would you put these categories? They are different categories that the law says.
In fact, while taking up this issue, on 16 to 24, an order.
Yeah.
16 to 24, there is order. Ultimately, although they have raised a grievance against the police department, the DGP cannot formulate a policy as regards reservation of a particular category. So, lordship has observed. Kindly come to 16 to 24.
Yes.
In PIL 6. Lord.
Respond number, who appears for respond number 4?
Yeah, the department has my friend is here.
You are for responding. What is his name? You are Arandas. So what is your stand? Have you filed your affidavit? You have not. You have. So what is your stand? Anyway, we'll see it on that date.
They were in fact to come up with the new instructions.
Oh, we'll see.
Item 16.
Deeply obliged. I may be permitted to leave, your lordship.
Yes, please.
May I visit your lordship?
Yes.
Lordship, regarding item 16, we received the affidavit in opposition from yesterday actually. So it's a voluminous.
Okay,
We need some more time for.
the counsel for the appellant seek some more time to go through the affidavit in opposition before addressing this point. List this matter on. So,
Economical and short date will be given by.
short date is September, mid of October. Keep it sometime 14, 15, 16, whichever.
Last part of September, madam.
Last part of September would not be possible.
Lordship 18,
Keep it any day.
16 October.
16th of October.
Chief Justice.
Item 17.
May I please your lordship?
Yes,
My lord, I apologize for not being present physically.
not
I would
at all.
love to address this, my lord, physically, my lord.
It's
My
for
lord,
the, yes,
the issue raised in this petition, my lord, is on the constitutionality of a provision in the Wildlife Protection Act. Is the
Yes.
proviso to subsection 2A and 2B, my lord, of section 40.
Wildlife Protection Act. Yes,
There's an exception carved out, my lord,
yes,
for live elephants.
yes.
Lord, and that is something that we are aggrieved by. And we've challenged it on multiple grounds.
Let's come to section 40 of the Wildlife Protection Act.
My lord, this comes, my lord, in chapter 5, which
have-
deals with trade or commerce in wild animals, animal articles and trophies. The chapter begins from section 39, my lord.
Yes, trade or commerce in wild animals, animal articles and trophies, all right?
Yes, my lord.
Yes,
Now, my lord, may I read the concerned proviso, that is section,
Yes.
or would my lord want me to read the entire section 40? That would give greater context, my lord.
let us read together. Yes, please.
I'll just read section 40. Every person having at the commencement of this act the control, custody or possession of any captive animal specified in the Schedule 1 or animal article, trophy or uncured trophy derived from such animal or salted or dried skins of such animal or the musk of a musk deer or the horn of a rhinoceros shall within 30 days from the commencement of this act declare to the chief wildlife warden or the authorized officer the number and description of the animal or article of foregoing description under his control, custody or possession and the place where such animal or article is kept. No person shall after commencement of this act acquire, receive, keep in his control, custody or possession, sell, offer for sale or otherwise transfer or transport any animal specified in Schedule 1 or any uncured trophy or meat derived from such animal or the salted or dried skins of such animal or the musk of a musk deer or the horn of a rhinoceros except with the previous permission in writing of the chief wildlife warden or the authorized officer. Now, my lord, 2A and 2B, my lord, which is the relevant clauses we are concerned with. No person other than a person having a certificate of ownership shall, after the commencement of the Wildlife Protection Amendment Act 2002, acquire, receive, keep in his custody, keep in his control, custody or possession any captive animal, article, trophy or uncured trophy specified in Schedule 1 except by way of inheritance. My lord, we mark these words. Except by way of inheritance. This applies to all captive animals, my lord.
Yes.
Every person inheriting any captive animal, I'm reading 2B, my lord.
What does this word inheritance mean? That if a person has a horse and if
Yes.
the horse breeds,
Yes.
then the other horse, the horse born would be the property, it would not apply. The proscription would not apply.
The way I have understood it, my lord, the person who's owning the calf, the mother, my lord, will be owning the calf in the cases of elephants which we are concerned with, my lord. And that's what, there's more clarity to this if your lordship refers, I'll take your lordship through the guidelines also. There's a 2008 guidelines, my lord, dealing specifically with captive elephant guidelines, my lord.
Let's say 2B.
Yes, my lord. 2B, every person inheriting any captive animal, animal article, trophy or uncured trophy under subsection 2A shall within 90 days of such inheritance make a declaration to the chief wildlife warden or the authorized officer, and the provisions of sections 41 and 42 shall apply as if the declaration has been made under subsection 1.
That's right, proviso.
Provided that nothing in subsection 2A and 2B shall apply to live elephant. This is the exception carved out entirely for live elephants, and more specifically, we are in the context in the present case is live captive elephants, but this exception that has been carved out, defeats the very object of the Amendment Act. This was inserted through an amendment in 2002, my lord. I have produced the Amendment Act also and the Lok Sabha debate, my lord. And but the first contention which I beg to submit before your lordship for your kind consideration is that this is violative on the face of it, because this carves out a separate legal regime, my lord, which defeats the object for which this whole amendment was inserted. And I'll take your lordship through the Lok Sabha debate. But the other aspect is that this is wholly arbitrary, my lord, and it's violative of Article 14 of the Constitution, my lord.
Now, there has been, as far as I remember,
My lord.
some litigation over this, especially with respect to elephants in temples of South India.
Yes, my lord. There are quite a few going on, and there are some pending also.
Tell us any concluded litigation with respect to this?
My lord, I'll have to check once about the status of those matters, but there was one matter which was pending before your lordships.
Yes.
That was pertaining to transfer of an elephant to Kerala, if I'm not mistaken, my lord, and which was going on. But I'll have to check the status because I'm not in the position to make a statement of whether that's concluded, whether a final decision has been given. That I'm not aware of, my lord.
This issue has been raised in many of the proceedings here in Supreme Court.
Well, at Supreme Court also it is pending in some cases because there are a lot of issues pertaining to safety of elephants during transportation also, because often elephants from Assam and more particularly, my lord.
Therefore, your submission is that with the proviso, with this proviso,
My lord.
elephants, captive elephants,
My lord.
for possession of captive elephants, there would be no requirement of declaring the ownership, custody to the chief warden.
Yes, the declarations are not mandatory insofar as elephants are concerned, and because declarations are not mandatory, therefore the other protective regime, my lord, which are in place for other captive animals, which your lordships will find in section 41 and section 42, which requires, my lord, the chief wildlife warden to.
India responded. What have
They
you?
have responded, my lord.
What have you said? Just with a brief idea.
Lordship, in the first round is Lordship, this writ petition is filed as a writ petition. I don't know what fundamental or legal rights of his has been violated. This at best can be a PIL.
This is a PIL.
No, this is a writ petition.
Writ petition.
All right, this is a writ petition. Okay. I mean, so far as Lordship, elephants are concerned, I have, I'll just pass on, Lordship. The central government has issued guidelines to all the states insofar as registration, ownership certificate, how they have to be cared for.
No, that is different. But
Lordship.
the proviso keeps the elephants out of other animals, out of the regime. Because for captive elephants, there is no need of any declaration.
No, Lordship. If your Lordship will come to the guidelines, okay, Lordship.
My lord, is this the 2008 guidelines, my lord?
It's the same guidelines.
My lord, it's part of the record, my lord, will find it.
That's all right. This is more convenient for us.
It's
My lord.
It's a pull-out.
Lordship.
Yes.
So far as captive elephants is also concerned, Lordship, Lordship will come to the second page, ownership certificate. All states, union territories would carry out a fresh survey of the captive elephants in their territory within a period of 6 months and report the number to the ministry. All captive elephants shall be microchipped, for which chips have been provided in adequate number to the state, union territories. Fresh ownership certificate be issued in the form annexed.
Therefore, this is in derogation of the proviso.
No, Lordship,
Proviso says that it is not required. So these guidelines are issued by which Ministry of Foreign Affairs?
Lordship, but these guidelines take care of that
No, that's
situation.
true. So therefore, the government believes that they are also required to be protected
Lordship,
with such disclosures. So
Lordship.
by these guidelines, the proviso should have been removed. Mr. Phuken, are you
My
Mr.
lord.
Phuken?
My lord, yes, please.
You have to tell us, the issue is, this issue is pending before Supreme Court and some of the other high courts.
My lord, this particular issue is not actually, this challenge to this provision is not pending consideration. That is my understanding, my lord.
We'll be required to see that. Just you make a specific statement after verifying. It can easily be done these days.
My lord, no, my lord, this particular, the challenge to the constitutionality of the provision, I am sure, my lord, it has not been challenged. There are other issues pertaining to transportation of elephants and implementation of guidelines. All these issues are pending. There was one order passed by the Honorable Delhi High Court, my lord, where a transfer of an elephant from Jorhat in Assam to a temple in Sainik Farms in Delhi was stayed, my lord, because under the rules, the Forest Department had not given the approval in the manner which the rules envisaged, my lord.
The guidelines would take care of your concern.
My lord, I am going to show from the record itself. In fact, I have a written submissions which would help your lordship. My colleague will hand over a short written submissions where I have made bullet-wise points, my lord. The counter affidavit filed by the state of Arunachal Pradesh, my lord, that
We will hear you on some other date.
no difficulty, my lord, no difficulty.
Courts and give a copy of this notes of argument.
My lord.
Mr. Chaudhary also.
In fact, the state of Arunachal Pradesh has stated on affidavit, my lord, that they are not able to implement these guidelines because of a lot of issues. But that is on the implementation part. My argument is that because of this provision, my lord, and because the
that would be a ground,
my lord,
a further ground for challenge, that with this kind of exception carved out by way of proviso,
my lord,
the argument is that this proviso is unnecessary because elephant also pachyderms are not endangered, but they're also species which need to be protected. Now,
my lord,
why?
and because they are not declared, my lord, therefore this also encourages illegal trade is my case, my lord, and therefore, in fact, there are orders passed by the Honorable Guwahati High Court, my lord, where elephants were sold, my lord, which is clearly not permissible under the Act, my lord.
How is it, Mr. Phuken? I'm slightly surprised. There are many animal fairs, markets where animals are sold. One particular market in the state of Bihar, which is said to be the biggest in Asia, there the elephants are sold openly.
Elephants, my lord.
Yes.
Well, what happens is that if it can be gifted, Miller. There can be a gift deed executed, or there can be a donation made, Miller.
1 minute, Mr. Phuken. And
Sorry, Miller.
those animal fairs, they are sold. The fair is declared open. It is inaugurated by chief minister and other ministers, and they're sold. The prices also are quoted in newspapers that particular baby elephant was sold for 25 lakhs or 15 lakhs or whatever. I would not remember the price. I was surprised. But how is it that in the cattle fair at Pushkar, camels are sold?
Camels, Millard, I don't think they come under this particular schedule, Millard. We are concerned with the schedule, with Schedule 1. And the elephant clearly comes under that.
All right. Mr. Chaudhary, now this guidelines which you have provided us, this is an admission of the fact that the authorities, the ministry would like the elephants to be preserved.
They are concerned.
So why the proviso? Why this proviso? Have you addressed that issue in your affidavit?
No, option.
Do that, Madam Expert. Please do that.
Yes, option.
The petitioner challenges the constitutionality of the proviso to section 40(2)(a) and 2(b) of the Wildlife Protection Act, Wildlife Protection within bracket 1972, which creates a special exception for captive elephants in relation to ownership, custody, possession, and control, which apparently is arbitrary, unreasonable, and violative of Article 14 of the Constitution. Mr. Fouquet, Mr. A. Fouquet, Mr. A. Fouquet, learned counsel for the petitioner, submits that this exception clearly undermines the very object of the Act of 1972, which aims at providing comprehensive protection to wild animals, birds and plants, for ensuring ecological and environmental security. The elephants are included in Schedule 1 of the Act, and therefore, they too are entitled to the highest degree of legal protection. The proviso under question can be used as a convenient tool for legitimizing illegal capture, trade, and consequent captivity of the elephants. Mr. R.K.V. Chaudhary, learned Deputy Solicitor General, however, has submitted that the Ministry of Environment and Forests for Project Elephant has come out with guidelines for care and management of captive elephants, which clearly requires all the states and union territories to make a survey of captive elephants in their territory and report to the ministry. All the captive elephants, according to the guidelines, are to be microchipped and ownership certificates have to be issued with respect to each of them for a period of 5 years, renewable for a further period of 5 years, in case there are no violations of the norms which are required to be followed. For elephants about which no declaration has been made, the guidelines directs that those should be confiscated. It is mandatory for the owners of the elephants to declare in writing in advance to the nearest DFO or to the authorized officer by the state government of the pregnancy of female elephants in order to get fresh ownership certificate of the calf. The certificate would be issued to the calves of the animals only after physically ascertaining that they are genuine offspring or after getting the DNA test done. But this is with respect to what? Elephants.
Elephants, my lord, the calves.
The baby of an elephant is also called calf.
Yes, my lord.
Okay. There are certain other guidelines concerning the transportation of elephants, housing and care, and feeding, as also retirement. The guidelines also takes care of controlling the cutting of tusks as well. We are at a loss to understand as to why this exception has been carved out in the proviso for elephant, which again seems to be nullified by way of guidelines referred to above, guidelines dated 8/1/2008 referred to above, which in fact puts the elephants in the same regime of protection, requiring declaration by the owners. Though counter affidavit on behalf of the Union of India has been filed, but this issue has not been addressed. Stop. Let a fresh affidavit be filed addressing this on behalf of Union of India be filed addressing this issue. Stop. Mr. Fuken is also requested, Blood Council Commissioner is also requested to bring on record the other, to inform this court about any other litigation pending before Supreme Court or any other High Court regarding this issue on the next date. Re-notify it. You have flagged a genuine issue, but I don't think there is any cause of concern because of these guidelines and whether they are being implemented. And nonetheless, why should that proviso remain in the statute?
Correct, my lord.
We
That's
will
the
see.
point, my lord.
2810.
May I request,
Yes.
my lord, may I request subject to convenience if it could be on the 24th of October, my lord?
24th of October, yes, of course. 24th of October.
Deeply obliged.
It is not inconvenient to my friend. Week thereafter.
You are appearing for?
I am appearing for the state of order.
That also is a party. All right.
State of Assam and Arunachal are also parties, my
All
lord.
right. When do you?
31st.
of October. 31st of October, Mr. Puket.
My lord, it's a final hearing. It's in the final hearing category. So if your lordship then please to keep it on a Thursday or a Tuesday, I'm okay with that as well, my lord.
30th. Re-notify on the 30th of October.
I'm deeply obliged, my lord.
All right. Mr. Chaudhary, you have to tell us what you have said that the guidelines are not being implemented. Difficult to implement the guidelines.
We have not really said that. What has really happened in Arunachal?
No. We are presently not on that issue. The issue is with respect to the constitutionality of the proviso, which casts an exception for one particular animal. Therefore, it can be understood as a concession in the act with respect to elephants because they could be traded, they could be transported. Now, guidelines would come only thereafter. There is a statutory provision, that's a central act. What is the rationale? He says that he will read out, he will point out the debates in the Lok Sabha and the background facts and the reason. But why this proviso?
Perhaps the option doesn't.
Not perhaps you tell us conclusively on that day.
On the lordship says that subsection 2. Transfer of an element, in any case, the proviso does not cover that. So transfer in any mode that is clear in a legal would in any case be part. It is only the declaration and the inheritance part which where the proviso comes.
All right, we'll see. We'll see on that. All right.
Item 18.
Yeah, this is again the order of creating what event. The question before your lordship asking whether the second wife of a deceased railway employee and son are entitled to pension under the Railway Pension Rule 1993, Rule 70 and 75. So that question has not been dealt by the CAT Guwahati bench. And CAT Guwahati bench only on the basis of CAT Guwahati bench only on the basis of there is a no declaration with regard to the second wife and son in the declaration certificate submitted by
Let's see
this is railway. This is railway. Now, my lord, I am coming to your lordship, the directly to the, and it is not a dispute before your lordship.
Give us a minute.
It's
The petitioner is the daughter of the second wife.
no. Petitioner one is the second wife and two is the son of the second wife.
Let's see the railway rules.
Railway rules I have entered that page start at page 52 of my writ petition. And the relevant portion is that page 54, it is a railway rule it is a separate self-contained railway pension rule. It is under this constitutional scheme. Then, my lord, the page 56, I am reading page 56 bottom. It is a 70 rule start as page 55, retirement gratuity or death gratuity. Then page 56 bottom, railway rule says, rule 70 sub-rule 5. For the purpose of these rules, rule 71, 72, 73, 74, family in relation to railway servant means wife or wives, including judicially separated wife or wives in the case of the male railway servant, husband including judicially separated husband in the case of a female railway servant. Then Roman 3, sons including stepsons and adopted sons. So these are the three, 1 Roman and 3, that my claim is that I am entitled under this rules 70, sub-rule 5, Roman 1 and Roman 3. Then, my lord, the 71 deals with the page 57, persons to gratuities payable. The gratuity payable under rule 70 shall be paid. Right.
No, no, that's right. What do you have to put it? It's fine. They're not- it's not there. Nomination. Were any nominations made by the deceased employee?
My lord, in the nomination, the name of the petitioners are not there. Problem,
Has any nomination been made?
yes.
That's what I'm asking.
That is,
They have not discussed them.
Case number 126 of our affidavit in opposition manner, name of the nomination manner.
Where
Case
is it?
number 126.
and the tribunal has been guided by this nomination. Without answering the rule.
126 is submitted in 2003, then 127, 2009, and again on 2014, that is in case number 128.
You made her a party,
Yes, Madam Chair.
you're appearing, not the first wife.
Yes, Madam.
What do you have to say?
I am the past legally very past wife and.
But you were judicially separated.
No, no,
No separation.
no separation. I am the past wife I have received. My name has been reflected in all the documents. And page 107, the learned, yeah, have reflected that family declaration, certificate, family, so on all the documents, my name has been reflected. During his service period, he has not disclosed the name of the second wife at any point of time.
It's a big man. Boy, she's not in. It's very. These are saying that for the corporate, it's only the family who five or five. So this, you may sort of look at this rule at page 56. Wife for wives including judicially separated wife.
Including.
Wives in case of a male.
Wives or wives including judicially separated wife or wives in the case of a male relay servant. Then my lord, I am coming page 65. The how the it will be given. Page 65, that is sub rule 7. Sub rule 7 of this rule.
where family pension is family 65 sub-rule 7, bottom of the page 65, where the family pension is payable to more widows than
Where
one.
are you reading?
65 bottom 7.
Yes.
Where the family pension is payable to more widows than one, the family pension shall be paid to white widows in equal share. On the death of widow, the share family pension shall be become payable to an eligible child. Now, my lord, I am coming to the division bench judgment, Bombay High Court division bench judgment, which has been carried to the Supreme Court and SLP also dismissed by the railway and relied on by the Karnataka High Court. This division really dealt with this rule of the railway rule and answered by. High Court of Bombay, Nagpur. There are 6 and 7.
Just a minute. No, the Supreme Court upheld it for a different reason.
Yes.
By the time the matter reached Supreme Court, the first wife had died and there were no issues with the first wife.
Yes.
And therefore it did not. But how can you say that section 11 of the Hindu Marriage Act has to be bypassed? Now this wives.
Is pretty.
Judgments do not help us. MS Gayon, you are appearing for the railways, no?
Yes.
Please ask Mr. RPD Chaudhary. These two judgments do not satisfy us.
No, there is, but
One negates the very concept of section 11 of the Hindu Marriage Act
that is contradiction.
on the ground of 39A.
And that is my surprising the division bench of the Bombay High Court.
Rules cannot be tinkered like this. Now, whether the rule. Any technical court. Another way.
And the
What are, under the general pension rules, the second wife also gets a share, no?
so it is
No,
very,
second wife doesn't get a share, children get.
children gets legitimate or illegitimate. But railways, that is what the division bench had praised this rule, that they have taken care of this. What will happen because total bed earner has been tied.
I mean, for the child, we are not in doubt.
That is it. That is
The
what-
rules or no rules will go
Yes,
back to any other central
yes.
government. pension.
Because I have enclosed the judgment of the Supreme Court in my writ petition.
With judgment.
That's Supreme Court in my writ petition also, regarding the illegitimate or legitimate character. Yeah.
That is not, that is not,
Rameshwari Devi, that I,
Mr. Nath, that is not troubling us.
yes,
What
yes.
is troubling us is the.
Interpretation of that rule, wife or wife.
Interpretation is the very justification of that rule here in the definition of family. Two wives under what circumstance? When the other is void. The marriage of the applicant or the petitioner is void. I mean, it's
That is
void, but
11,
it's void.
section 11.
Section 11. So who can tinker with that? And Supreme Court, in that case, which judgment was this? Which High Court? The first judgment, Mumbai, That was allowed on a different, in a different context.
Because no, there is no claimant, another claimant. There is no dispute now.
But the second wife had died, first wife had died.
Died.
Paul, Mr. Chaudhary, we need to decide this. So that it does not cause a precedent like Bombay High Court. Not now. Money has been paid to you, mister.
Yes, madam. I have received some amount, my lord, but exact amount I cannot. After the judgment passed by the honorable cat, there is no stay
You
order.
got your husband, still you got the payment. This lady lived with her husband.
No, my lord, as per my written statement, during,
We have seen the affidavit of the first wife.
yes, madam.
Yes.
Debit,
We have seen her affidavit.
Yes.
She admits
Long,
marriage.
since long she is
but during the COVID period, also, he is,
And you are also getting maintenance.
yes, madam, at that time.
We have nothing against you.
Yes.
But then the child born out of the second marriage must be paid.
My lord, till the age of 18, my lord, not
no.
if they are a major, my lord, I think to my limited.
Railway rule
they will not
says
get.
25. That is, I have enclosed it.
Well, Mr. Chaudhary, what kind of rule is this? Difficult for us to decide.
Yes,
This is one and only rule.
wipes.
Inform Mr. Chaudhary that we would be questioning the correctness of this rule, the constitutionality of this rule also. So therefore, he should be ready with that, and
Yes.
you also assist him
Yes.
because he hates you. Therefore, not that we are dissatisfied with you. You have given your input.
Wipes mean to my limited knowledge in respect of other religion, madam. And with the permission of.
The definition.
There is,
There is no definition.
no underlying interpretation is there.
Assam Pension, it is now. Assam Pension.
CCF to motor.
Children. That's good. That's 129 of us. I had read. Let's just look at the fact. That would not.
Assam Services Pension Group.
It is not a.
এখানে Assam Services Pension Group. The petitioner is the first right. Petitioner is the second right.
The petitioner, number one, is the second wife of the deceased railway employee, whereas petitioner number two is a minor son. They are aggrieved by the order passed by the tribunal dated 22nd of March 2023, passed in OA number 040/00264/2020, whereby their claim for being paid their share in the post-retire, in the death cum retirement gratuity, death cum retirement benefits of the deceased employee has been rejected. On perusal of the order impugned in the present petition, it appears that the claim of the petitioners was rejected on the ground that the deceased railway employee was married to one Malti Saikia, with whom he was never divorced. Thus, the marriage of petitioner number one with the deceased employee was a void marriage according to Section 11 of the Hindu Marriage Act. Hindu Marriage Act. The learned counsel for the petitioner, however, has drawn the attention of this court to
Page 56.
the pension, section 70 subclause 5 of the Railway Servants Pension Rules, which provides that for the purposes of Rule 71, 73, 74, which deal with persons to whom gratuity or death cum retirement gratuity is to be paid, the family would include wife or wives, including judicially separated wife, or wives in case of a male railway servant. This being the scheme of payment of pension, the learned counsel for the petitioner asserts, the petitioners are entitled to a share in the pensionary benefits. Entitled to a share in the pension. The records reveal that respondent number 5, first wife of the deceased employee, long separated with her husband because of his intemperate behavior, but was getting maintenance from her late husband. There was neither judicial separation nor divorce, and the marriage subsisted till the time the deceased employee survived. We have also seen the two judgments of Bombay High Court and Karnataka High Court respectively, wherein there is a clear acknowledgement of the right of a second wife to receive family pension / death gratuity, death cum pension gratuity, death gratuity, in view of the definition of family in the railway service rules, which includes wife or wives, as the case may be. In the state pension rules and elsewhere, a second wife which marriage is void is not entitled to pension, but children born out of the second wife are definitely entitled to their share in the pension. We have requested Mr. R.K.D. Chaudhary, learned Deputy Solicitor General, to assist us in this matter. Next day, notify on your date sometime early October. We'll hear you on 14th of October.
My lord, I will.
Please tell it. Keep each other.